apologies from Mr. Tom Elliott, who's unlikely to be in attendance. Draft minutes of the meeting held on the 26th of November are available in the folder, and if members are content with their accuracy, then I'll sign them accordingly. Agreed? Matters arising.
Yes, Mr. Chairman, I just make one comment. Chair, last week in the discussion which we had with CARE and other organisations, I had to leave the room to take a phone call, and on looking at the record of the meeting, I was very concerned to note what I would describe as a gross misrepresentation of how Mr. Poots represented my comments in that meeting. I find that very unfair and unfortunate that someone should take the opportunity of me leaving the room to make those comments. I just want to place the record straight. I was making a point about legitimate treatment options. I wasn't suggesting anything other than that, and I was making a comparison between the private health sector and the NHS. Thank you.
Your comments are duly noted. If no other matters arising, then we'll move on to the next item, which is the Northern Ireland Human Rights Commission attending to give evidence on the proposed amendment the committee consulted on that Jim Wells had put forward. The relevant section of the Human Rights Commission submission is at pages 25 to 32 of your meeting folder. Page 3 of the table pack is there for ease of reference. Are the Commission here?
Which Commission?
Yeah. I guess in them.
When the Human Rights Commission appeared at the committee on the 12th of November to give evidence on the provisions in the Justice Bill, members asked the Commission to consider the application of violent offences prevention orders in relation to children, as this issue had been raised by a number of organisations. The Commission has provided a written response on the issue, which is in your meeting folder, and there will be an opportunity, if members wish, to explore that particular matter further. So if the Commission members would like to take their seats at the top table, we're ready. Yes. Can I welcome the Chief Commissioner, Les Allenby, Dr. David Russell, Deputy Director, and Ciara Hyde, who is a researcher, all from the Northern Ireland Human Rights Commission, to the meeting. And this session, as with previous ones, will be recorded by Hansard and then published in due course. So you're all very welcome to the meeting, and at this stage I'm going to hand over to Mr. Allenby to briefly outline the key issues in respect of the amendment that they have made comment on, and also, if you can, the application of violent offences prevention orders in relation to children. If you want to separate those two, I'm happy to separate it.
Yeah.
And then if you want to deal with the Jim Wells amendment first, then we can proceed.
Yeah. Well, Chair, I hope you've received the correspondence that we had sent to you after the last meeting. You and your colleagues, we take it, have it. Okay. Yeah. Let's deal with, I guess, the main issue this afternoon. And if I could just first of all say good afternoon and thank you for inviting us up. I'll ask my two colleagues briefly to introduce themselves, and then I'll go straight into our submission, and obviously we're happy to take questions from you and colleagues on the issue.
David Russell, Deputy Director.
Ciara Hyde, I'm a researcher.
What I intend to do this afternoon is set out what I think are the international law, the current state of play, and the court decisions that are relevant to this issue, and then, to having established those principles, look at the particular amendment that is before the committee to the Justice Bill. If I start from the position of that ending the life of an unborn child and the right to termination in law is currently prohibited absolutely in statute, as you know, but in common law is available, but in a very restricted set of circumstances. In effect, termination is allowed where the continuation of the pregnancy threatens the life of the woman, or she has a real and serious, or there's a real and serious impact on a woman's mental or physical health, and that impact must be permanent or a long-term one. And currently, any breach of the law under the Offences Against the Person Act 1861 can lead to a criminal sanction of up to life in prison. As we see it, the amendment that's before you today to the Justice Bill seeks to further restrict access to support in the limited circumstances where a termination would be lawful. Our submission, which you have, is based on, as I said earlier, the current state of international human rights law, and in particular around Article 8 of the European Convention on Human Rights, which is the right to respect for private and family life. The similar provision is also to be found in Article 17 of the International Covenant of Civil and Political Rights. And this response reflects our understanding of the legal position and the case law. And it's probably important to say as well that the Convention is a living instrument. It moves with the times, and there's been considerable developments in the case law in recent years. So I think the first starting point for us is that the Court has recognised the right to respect for private life is a broad concept. It encompasses a person's physical and psychological integrity, and it includes the decision whether to or not to have a child or to become parents. So Article 8's essential object is to protect the individual against arbitrary interference by public authorities, but it's important to say it's a qualified right, so that any interference must be in accordance with the law, necessary in a democratic society, or, for example, for the protection of health and morals, and the rights and freedom of others. So the right is not absolute, it's qualified, and in practice, if there is to be an interference with the right to private life, it must meet a pressing social need, it must be proportionate, and it must be in pursuit of a legitimate aim. And the right to private life is also a positive obligation to secure the effective right of that physical and psychological integrity. It's also important to say, I think, too, that the European courts have also recognised there's no consensus amongst convention states on the scientific and legal definition of the beginning of life, though there is a consensus amongst the substantial majority of contracting states of the Council of Europe towards allowing abortion in certain circumstances, and therefore there obviously will need to be, on occasions then, attempts to resolve the conflict between the rights of the fetus on the one hand and the mother on the other. And what the courts have done is recognise that those rights are inextricably linked, and in the absence of a common approach amongst states, a fair balance must be maintained between individual rights and the public interest. And there is normally a narrow margin of appreciation where an individual's existence or identity is at stake. But in the absence of a consensus, what the European Court has said in a number of judgments is there is a broader margin of appreciation in dealing with these issues. So that discretion isn't unlimited, but there is a discretion on how you deal with that. So, having talked, therefore, about the broad margin of appreciation that's given to a state as to when the circumstances in which a termination is permitted, once there is a decision and once there is some legal framework, then that framework must be devised in a way that is coherent and allows the different legitimate interests to be taken into account adequately and in accordance with the obligations, the positive obligations derived from the Convention. And again, it's important to say that there are no explicit procedural requirements, but those procedural requirements must be sufficient to safeguard the positive obligation. The Court has taken the view in some jurisdictions, in some countries, that those legal restrictions on termination or on abortion, when combined with the risk of incurring criminal responsibility, can have a chilling effect on doctors and clinicians when dealing with an individual case. And it's also, I think, important to say that the courts have held that provisions regulating the availability of lawful abortion should avoid having that kind of chilling impact. So there needs to be effective procedural mechanisms capable of determining when the conditions of a lawful abortion exists. And the court has said that that shouldn't be something that is normally left to domestic courts to decide. So those kinds of clinical decisions should not be readily pushed over to courts to decide. There should be sufficient clarity to allow the clinicians to make decisions knowing whether they're lawful or not. And the rights guaranteed by the Convention, finally, must be practical and effective and not theoretical and illusory. So the positive obligation of the right to a private life must be enacted in a way that is meaningful. So, having said all of that as a kind of preamble, and I recognise that's a rather lengthy preamble, I want to turn to the proposed amendment in hand today and apply some of those principles in practice. The purpose of the amendment, as the Commission reads it, is to propose an offence to end the life of an unborn child at any stage of that child's development, with the sanction of a fine and up to 10 years in prison if the person commits an offence. And there are a number of defences provided to that, so that where the act or acts end the life of the unborn child were lawfully performed on the premises by a health and social care trust, then that is a defence. Or if the act or acts ending the life of an unborn child were lawfully performed without fee or reward in circumstances of urgency, when access to premises operated by a health and social care trust was not possible, that's also a defence. We have a number of difficulties with this amendment. We've outlined them to you in our submission, but I will set them out very briefly, and then we can move to questions. The first, I think, is that the clause is so widely drawn. There are a number of terms in the clause that are not defined, but it could encompass almost anything, including, for example, certain forms of contraception, for example, the morning after pill, which are legally available in Northern Ireland. The any act or acts that end the life of an unborn child is a very widely drawn term. In our view, the amendment lacks clarity, and yet, having lacked clarity, it intends to create a criminal offence punishable with up to 10 years in prison. And applying the principles that I've enunciated earlier, that while you're entitled to interfere with a woman's right to physical and psychological integrity, it's a qualified right, there's a margin of appreciation, it must be applied proportionately, and the courts have regularly held that criminal sanctions that have a chilling effect on doctors and other clinicians is to be avoided. And it seems to me that this amendment falls completely into that trap. It's interesting that, for example, in the A, B and C and Ireland judgment, the court looked at the uncertainty created by the 1861 Act, albeit obviously in Ireland modified by a number of provisions, including constitutional ones. They felt that the 1861 Act did have a significant chilling factor for both women and doctors in the medical consultation process, and that's regardless of whether those prosecutions had been pursued in reality. So, in our view, and I will finish really on a quote of the court in the ABC case, in Ireland there is a striking discordance between the theoretical right to a lawful abortion on the grounds of a relevant risk to a woman's life and its practical implementation. And A, B and C, in particular where the threat was to a woman's life, held that that lack of clarity was contrary to to Article 8. It dealt with in a different way the issue of abortion being sought for health and well-being. And therefore, in our view, if this amendment was taken up by the Department of Justice, we think it's contrary to international human rights standards and in particular Article 8 of the Convention.
Okay, thank you very much. Just a couple of points that I wanted to raise. In terms of the example that you use, the A, B and C versus Ireland, looking at that judgment, there's a paragraph in it, there's paragraph 214, and it said Article 8 cannot be interpreted as conferring a right to abortion. It also said in paragraph 241 of the judgment that the prohibition of abortion for health and well-being grounds did not exceed the Irish state's margin of appreciation in Article 8. So how do you counter those elements of the judgment with what you've said?
Well, the starting point of my understanding of the rights under the Convention is the Convention doesn't create an absolute right to an abortion. A state does not have to legislate and create rights to termination. But where it does, and in both Ireland, in common law in Northern Ireland, there are rights to termination in very limited circumstances. And where those limited rights apply, then they must be regulated in accordance with the right to private life in Article 8. So I wouldn't disagree with you, Chair, in saying that there isn't a kind of, the Convention says there must be a right to termination, but where there is, it then must be regulated in a way that's coherent, that is clear to women and clinicians and those who are involved in that, and it must be provided in a way that makes that right real. So I don't think it's incompatible with kind of what we've said in terms of paragraph 214.
The issue, as I see it, is that the previous very restrictive abortion law in Ireland was able to sustain the challenge in terms of the ECHR. So the very restrictive nature of it, it was able to sustain that. There was an issue in terms of when it came to a matter of exceptions around life and health.
The answer, I think, to that is yes and no, in as much as in the circumstances where you were dealing with health and well-being that was not a threat to the life, the court held that they were not going to interfere and declare that it was incompatible with Article 8. But the case in C was the individual who was faced with a threat to her life, or at that time when the facts were there, affecting her were, then in that case, the lack of certainty and clarity and the circumstances, then the law as it stood in Ireland at that point was contrary to the European Convention. So there's not a straightforward yes and no answer to that question.
Was it contrary to it in that it wasn't clear? Obviously, in the case of C, it was a life-threatening cancer. So was it that there was no clear procedure to determine in that particular scenario that it was found against?
My understanding of C was that the arrangements and the framework that had been set in place was so lacking in clarity and coherence that effectively what the court said was that right, Article 8 right, could not be properly enacted by the woman in this case, and therefore it was contrary to the Convention. And that what was needed was a very clear setting out of the position so that clinicians and women should understand and know what were the circumstances in which termination was lawful and what were the circumstances where it was not. I'd be looking to my colleagues, but is that a kind of
in the case of
accurate summary of?
Yeah, I mean, just also the criminal aspect, and that was obviously one of the other issues that was considered by the court as being an additional concern, because of the impact of that on both women and the practitioners, which was mentioned previously by the Chief Commissioner.
In the case that's referenced, I think, about P&S v Poland, is it not the case in Poland they conferred a very positive right for abortion?
Well, there is a right to an abortion in Poland, but it's in again rather restricted circumstances. And therefore, again, the issue in the Polish cases has been that how you then actually enact the rights that have been given, and much of there have been a number of Polish cases, have often been about what happens in practice when somebody appears to fall within the legislation, how then, if you like, and a little bit like this amendment, how then that actually operates in practice in terms of how the clinicians deal with a situation where the termination appears to be lawful, how that's handled. And again, the issues have often been about a lack of clarity in terms of how the law operates in practice in Poland.
The issue that I see in the Commission trying to draw a parallel with Poland, I think, is misleading, because the case that's referenced is where the state had conferred a positive right for an abortion. There was an individual case and around how they could access that right to abortion that was provided for by the state. Northern Ireland doesn't provide any positive pathway for abortion. It is only a defence, as you know, so there is no positive pathway for abortion in Northern Ireland. So the parallel that's being drawn, I would suggest, is one that would be hard to sustain.
I'm not sure, Chair, I agree with you. I think the principle, which is that in Northern Ireland your right to a termination comes from common law, essentially, rather than statute, except is different from the situation where in Poland the limited rights that you have come from legislation. But nonetheless, there is a right in limited circumstances in Northern Ireland to a termination. They've been established in common law, it's judge-made law, and that's the law of the land. And in those circumstances, the need then for a proper regulatory framework, coherence, to make sure that those rights that have been set by judges and judgments can be properly enacted remains. The same principle applies in Northern Ireland or in Poland.
Okay, in terms of the actual amendment, in what way does that amendment change the law in terms of your right to have an abortion? Your language was that this creates a barrier or is an impediment to it. In what way does the amendment change the law on which the grounds for a defence being made for an abortion is facilitated?
Yeah, well, I suppose let me give you a couple of examples. The first, I think, is under the 1861 Act, if you commit an offence under that statute, you can face up to life in prison. This amendment starts without prejudice to that, then creates a new offence of up to 10 years in prison. Now, I'm not sure that if you have without prejudice to the 1861 Act, how you can, and you're saying, therefore, we're not attempting to modify in any way the 1861 Act, and yet you're creating an offence that, so it's not clear to me whether, in fact, if you committed an offence under this amendment, you would be left with facing 10 years imprisonment as opposed to life imprisonment. That might seem slightly specious, because in our view, criminalising this in any event is inappropriate. But if I take a second example that's perhaps more relevant, than if you take, for example, the issue of the defence, that you can only manifest a defence if, for example, you could show that the woman could not have gone to, that it was urgent and the Health and Social Care Trust couldn't have provided care, for example. Now, there are other services, NGOs and other organisations, private organisations that provide these services in Northern Ireland. And I think it's probably important that we're not talking about one organisation. There are a number of organisations that provide alternative services. And I assume they exist because people use those services for whatever reason. don't want to impute any kind of motive as to why someone would decide to use a service other than one provided by the Health and Social Care Trust. But nonetheless, people do. Now, quite frankly, how you interpret this amendment, so that if somebody chooses to use a private service for their own reasons, perhaps they're worried about their own kind of privacy or their personal needs or whatever that reason is, then if they say, for example, to clinicians in a kind of private or an NGO sector, I don't wish to avail of the health service in these circumstances, I wish to avail of your service. Now, does that, and it's urgent, is that sufficient a defence for this amendment? I don't know the answer to that, but I don't think it's clear whether that's a sufficient defence. Has it got to be that it's so urgent that the Health and Social Care Trust facilities are all closed and not going to open for a period of time? So the clarity that I think you need to make a decision as a clinician, for example, in this case, or as a midwife or as a nurse or anyone else involved in this, I don't think is there. And if you're going to say that if you get this wrong, you make a judgment and you can face up to 10 years in prison, then I think the idea of having a chilling effect of this amendment, to me, is pretty clear.
And is it not chilling that it's life imprisonment?
Well, I think creating any criminal sanction of the kind of up to 10 years or life is clearly has a chilling impact, and I don't think 10 years is going to make much difference between whether you face life in prison or 10 years. But the earlier point I made is simply that the amendment is drafted, which talks about without prejudice to the 1861 Act, it doesn't seem to me to be clear actually whether, if this amendment applied, whether actually you'd be facing 10 years or life imprisonment. If you ask me candidly, does it really matter in terms of the chilling impact? No, I don't think 10 years in prison is going to have any less of a chilling impact in terms of trying to have the wisdom of Solomon and make a decision about these kinds of issues over life imprisonment.
Ian made a comment about criminalisation as inappropriate. What do you mean in terms of this issue around the criminalisation being inappropriate?
I mean that our law should be sufficiently clear so that if a clinician or if somebody, whether in private or public sector, is having to make a decision about whether it's appropriate to assist somebody or undertake a termination, then that person should know and be clear that I'm acting within the law. There shouldn't be any uncertainty. So that nobody, if you like, should feel that they were acting within the law and it turns out that in their genuine and honest belief they've stepped the wrong side of a line. It should be absolutely clear. And in my view, the law as it stands in Northern Ireland at the moment, with or without this amendment, it's not clear on what that position is in all circumstances, except that in some circumstances it may well be clear. And if clinicians take certain decisions, it may well be way beyond the line where you could say, I simply didn't realise what the law said. But I don't think the law has the kind of clarity that we need to ensure that people understand. And I take some reassurance in that view from the in kind of earlier Department of Health consultations, for example, around kind of the guidelines that we've read what the Royal College of Midwives, the Royal College of Nurses have said, and they've said it's not clear. So if those people are not clear in terms of what the law says and they're expected to abide by the law, then I think that is a problem in terms of the current framework that we have.
So it's not that the Commission, in your commentary, is opposed to the criminalisation as a way to regulate the issue of abortion?
Any criminalisation needs to be proportionate. It needs to be clear and proportionate in terms of action taken. I don't think the Commission's position is there are no circumstances in terms of termination where where it would be unreasonable to create a criminal offence. What I'm saying is, in terms of the law we have at the moment, I don't think that proportionality and the lack of clarity does, with the impact that it has, the chilling impact that it has, in our view, that's contrary to Article 8 of the Convention.
Well, the two issues there about clarity and proportionality, I think we can have a long discussion about that. Is it the Commission's view that the law as it is just needs to be very clearly outlined, or that the law needs to change?
I think our position is, and we've made this clear in correspondence to the Department of Justice, there are certain circumstances, for example, where we think termination should be allowed beyond the current law. That includes, for example, where there's a serious malformation of the fetus, where there's a lethal malformation of the fetus, and in circumstances, for example, where there are people are the victims of sexual crimes, for example, rape and incest. And in those circumstances, we think that both case law and what the CEDAW committee have said mean that actually our legislation should be extended to allow for termination in those specific circumstances.
The issue about the balance of rights is one then that leads you into that debate.
It does.
Where does the Commission believe that the rights of, I think you described the unborn child as a fetus, which I'm assuming actually means unborn child when you translate it. But
yes.
I noted you chose the word fetus. When are rights ascribed to the unborn child? At what stage?
Yeah. Well, again, the Commission's position is essentially we start from, again, what does human rights law say on this? And again, and it's been relatively recently clarified once again, which is in the case called Centurk versus Turkey. And what it said, and this is now a long-held position, and I'll quote it, I think, because I think it's probably important to kind of put it on the record. It's that the court reiterates that in its judgment in the case of Vaux versus France, the Grand Chamber held that in the absence of any European consensus on the scientific and legal definition of the beginning of life, the issue of when the right to life begins comes within the margin of appreciation which the court generally considers that states should enjoy in this sphere. The Grand Chamber thus found it's neither desirable nor even possible as matters stand to answer in the abstract the question of whether the unborn child is a person for the purposes of Article 2 of the Convention. And since then, the Grand Chamber has had an opportunity to reaffirm the importance of this principle, again in the case of A, B and C versus Ireland, in which it pointed out that the rights claimed on behalf of the fetus and those of the mother are inextricably interconnected. And in this particular case, the court then held it sees no reason to depart from this approach adopted in these cases and considers it unnecessary to examine whether the applicant's complaint as regards the fetus falls within the scope of Article 2 of the Convention, the right to life. So where I think the court stands is it's not prepared to make a clear statement of when and if the right of an unborn child commences. It's a matter for the contracting states to decide in the absence of any consensus, and I think this is really important. The rights claimed on behalf of the fetus and those of the mother are inextricably linked. In other words, you can't decouple them and simply say there's a right on here and a right over here. The two are linked.
So you accept that it's entirely a matter for the Northern Ireland Assembly to determine?
I accept that beyond where the existing rights are, and they have to be regulated, and in the circumstances that I've also outlined in our correspondence that we've had with the DOJ, for example, again in sexual crimes and in matters of lethal and serious abnormality.
That's your view as a commission. The commission is not the legal authority. It's
yes.
The margin of appreciation falls to the state. Abortion law is entirely devolved, so therefore it's for the Northern Ireland Parliament to deal with. So does the Commission respect that it's actually for politicians to determine this issue, which current law is very clear on?
Yeah. The answer is yes, I do, with the caveat that the margin of appreciation is not unlimited. It's broad, but it's not unlimited. Therefore, international human rights law does play a role in this, but it doesn't create an absolute right to, if you like, abortion in a vast set of circumstances. That's a matter. How it's regulated, where the circumstances within that margin of appreciation, within what we already have, and within some of the parameters I've outlined. Sorry, that's kind of a lot of caveats, but within that, then the politicians can obviously decide where the legislation sits.
And you accept it should be for politicians to deal with?
Providing they meet the international...
That makes you standing in judgment. That's the problem with all of your caveats, that politicians can deal with this so long as I think that that's what they're doing. Otherwise, the Commission, I take it, are considering being a Trojan horse when it comes to abortion and trying to change the law through the back door.
With respect, I don't think it does. And let me say, first of all, when I say it's within international human rights law, I don't mean that somehow I am the arbiter of the circumstances. The UK government has signed up, the Irish government has signed up to international human rights conventions. They've ratified them. They have to live within them. In some cases, they're justiciable. In other cases, they must report to the treaty monitoring bodies. So we're talking about a set of standards that governments have signed up to. In this case, the UK government has signed up to. It's not me who signed up to it. So you've got to act within what the UK has signed up to.
Well, again, you're wrong in that respect, because when we visited the European Court of Justice and we questioned the Vice President of the European Court of Justice, he made it explicitly clear that within the United Kingdom, Northern Ireland as a devolved region would attract the same margin of appreciation that would be afforded to the United Kingdom as a whole. So to make that comment that we need to fulfil what the United Kingdom are signing up to, actually that's not how the European Court of Justice considered it when I asked them. And specifically around the amendment, we asked, was it reasonable for a state to determine that this service, if you want to call it that, should be restricted to the state? And that's ultimately what the amendment is about, whether the private sector should be involved in the ending of life, or whether the state is of a view that, given the seriousness of what we're talking about, it's not going to the private hospital for a knee replacement or some other operation to be carried out. It involves the ending of life. Is it proportionate then for the state to decide we're going to restrict that to the state being in control? And again, the Vice President, and maybe it might get to his chamber at some point, made it clear to us that yes, it was reasonable for us to do that.
I suppose I'd make 2 points, and the European Court of Justice does take into account the European Convention on Human Rights, but it's normally dealing with a different set of issues in terms of the Convention, in terms of the European Court of Justice. But if I go back to the A, B and C case, because I think that helps answer this question. In terms of Ireland, you had the 1861 Offences Against the Person Act. You then had the constitutional amendments around the issue of termination. You had a number of referendum around various aspects of this. You then had a lack of clarity in terms of then where the state of the law was in terms of clinicians behaving within that. And the European Court felt that it did have the right to deal with whether termination, either for health and well-being or whether the life of the woman was at risk, was something that fell within the domain of the court. So I don't think I'm kind of asserting a personal kind of view. All I'm saying on behalf of the Commission is this is where the law stands. And the 1861 Offences Against the Person Act is an act that is, is Ireland-wide, and we've had examples of where it's been looked at, the other developments behind it. So I don't think it's a kind of untrammeled right for politicians to decide this. But I do say that there is a considerable margin of appreciation.
Okay, I appreciate members. I've taken up a fair amount of time, so let me bring other members in. Mr. McGuinness.
Yes, I understand your arguments in relation to the amendment. You say, look, in my belief or the belief of the Commission, there's a common law right to abortion. I don't accept that, but anyway, that's the basis on which you're presenting your proposition. And then you go on to say that because of that, Article 8 can be engaged in relation to the amendment. I think that's your basic argument. And then you go on to say, and I think this is a huge leap, that the Commission is also of the view that abortion, the right to abortion, is something which could arise out of Article 8. That's my understanding of. I hope I'm following your argument accurately. But that's, to my mind, there's a big leap from consideration of the criticism of this particular amendment, and then going on to say, by the way, in terms of the wider consideration of these matters, a right to abortion could arise out of Article 8. Now, that's as I understand your argument. And I disagree with your conclusion, but that's the argument. I want to try and understand your argument.
Well, I mean, it's in our submission, so
well, I've read your submission,
sure.
and I've tried to follow it. And could I say that in relation to most of the authorities that you quote are Polish authorities, and as the Chair has said, there's a very clear situation in Poland where abortion is clearly regulated by law, and there are restrictions in Poland in relation to abortion. But I would suggest to you Ireland, Northern Ireland is quite different from that situation.
Well, I think it's probably a similar question to the one that Chair asked, and I accept that in Northern Ireland, the circumstances in which a termination is allowed has been developed by the common law. It's not been developed by statute. In Poland, it was developed by statute. But I think the principles then, once you have got a right in certain circumstances, then I think Article 8 is engaged. And I think the European Court of Human Rights, in both the Ireland case, where the legislation is not that significantly different, albeit augmented in a different way in terms of constitutional amendment from the position in Northern Ireland, that Article 8 is engaged. And interestingly, even in the circumstances where in the A and B part of the A, B and C case, in other words, where the termination was about the health and well-being of the woman, the courts held that Article 8 was engaged. They decided that it was the circumstances in which a person could deal with the issue, including travelling across the Irish Sea to Britain for an abortion in the case of A and B, was such that there was a sufficient qualified right there. But Article 8 is engaged. I don't think there's any dispute, I wouldn't have thought, about the engagement of Article 8.
Well, I would dispute that, because I don't think that there is a right under law in Northern Ireland to an abortion. But, you know, that's a difference of opinion that we've got. If there is no right, then Article 8 cannot be engaged. That's my view. The further point I would make, just reiterate this point, it's very clear in the ABC case that Article 8 cannot be interpreted as conferring a right to abortion. And that's why I talk about the big leap that you've made, the big jump that you've made. Because clearly throughout the European cases, it's clear that there is a margin of appreciation given to the state, and that Article 8, as of itself, does not create a right to abortion.
I don't think the Commission is arguing that Article 8 creates a right to abortion. What we're saying is that the common law,
But sorry,
the courts have set out certain circumstances, which I discussed at the beginning, where termination would be lawful, and therefore when, in those circumstances where there are circumstances where termination is lawful, then in terms of a regulatory framework, and in terms then of the woman's right, in this case, to a private life, is engaged. That's the position of the Commission.
Well, maybe I misunderstand what you're saying. I thought that you then went on to say that you believe that there should be a right to abortion under restricted circumstances. That's the view of the Commission.
The view of the Commission is, having regard to what the CEDAW committee have said and having regard to the jurisprudence, there are certain additional circumstances where we believe...
But the jurisprudence based on Article 8?
Yes. So in the issue of sexual crimes, for example, the victim of rape or incest, for example, or where there is a lethal or serious malformation of the fetus, our position is that we think that should, in those circumstances, termination should be lawful.
You're saying, you referred to CEDAW. Leave CEDAW aside. If CEDAW wasn't there, just forget about CEDAW for the time being, right? Because it's not justiciable in this jurisdiction as such, right? But Article 8, obviously, if it's engaged, you can. But I understood that the premise of your argument in relation to abortion, in restricted circumstances, I understand the point that you're making, that it was based on Article 8.
Well, it's based on Article 8, Article 3 and Article 14 in terms of the absence of termination in circumstances of lethal and serious malformation and sexual crimes. It's beyond Article 8. I mean, I'm quite happy to put on record, for example, if you were asking me, for example, is there some kind of legal requirement for the Northern Ireland Assembly to enact the exact equivalent of the 1967 Abortion Act in human rights terms? I think the answer to that is no. I mean, I understand kind of the position is, the 1967 Act cannot be replicated. I can't make an argument that says under human rights law it must be, the 67 Act must be enacted in Northern Ireland based on a human rights argument. I understand that. Now, that's not me then saying that there is a kind of position of absolute autonomy of the Northern Ireland Assembly to decide this, the circumstances. There are some, in our view, legal human rights issues about when termination should be lawful. It's not a kind of imposing the 1967 Act, for example, on the Northern Ireland Assembly, and it's putting aside kind of views of whether, that's a straightforward legal position rather than a kind of position of personal,
Can I ask you, I mean, one of the principal provisions of the 67 Act relates to a fetus suffering from some form of difficulty in terms of malformation, that sort of condition, and there is provision there for abortion right up practically to birth. Are you saying that that provision is the provision that you're saying that the Assembly should consider?
The Commission's position is clear. International human rights standards do not require the Northern Ireland Assembly to enact the 1967 Act. We think that's clear. The Commission doesn't take a position on what the abortion law should be in Northern Ireland. What the Commission's role is to determine is what do international human rights standards and jurisprudence say about this issue. And in terms of this amendment, what we think it says is that this amendment would be proved to be unlawful. That's our considered view, and it would be contrary to Article 8. and I think I've kind of come back to where we are with what we're discussing today. That's our position. The Commission doesn't take a specific view on the issue of the law on abortion, other than to look at what international human rights standards have to say.
But leave aside the 1967 Act. You're saying that there ought to be provision for abortion here in Northern Ireland, arising out of Article 8.
I'm saying that under Articles 3, considering Articles 3, 8 and 14,
Yes.
the Commission's position is that in circumstances where a woman has been the victim of a sexual crime, for example, incest or rape, or where there is a serious malformation of the fetus, then termination should be lawful. Yes, that's the Commission's position, and that's the correspondence we've had with the Department of Justice.
Can I ask you, in relation to the draft Bill of Rights that the Commission presented to the Parliament, was there any provision in relation to abortion in that?
I can speak to that. There was a provision on reproductive health care in the advice,
Yes, but was there
but
any
no
provision in
specific
relation
provision
to
on abortion.
And can you tell me why there was no provision?
It was a decision made by the then commissioners.
Yes, but I mean, you inherit that commission. It's not something that you can say, well, that was somebody else. Same commission.
Well, there was a lot of issues where the Commission's mandate under the Bill of Rights was very specific. So it was provisions that would supplement the European Convention on Human Rights to address the particular circumstances in Northern Ireland. So it was a narrow mandate. It wasn't a broad mandate to look at. It wasn't free-for-all in terms of human rights, and what provisions the Commission might have liked to have put forward and recommend for a possible Bill of Rights for Northern Ireland. So it was very particular to the mandate arising out of the agreement. Some of the issues that are being raised here at the minute probably would have gone beyond the mandate of the Commission, in the Commission's view at that point.
Yes. And would not another reason be that there was no consensus in relation to this issue?
Amongst the then commissioners?
Not amongst the commissioners, amongst the forum that was dealing with the draft Bill of Rights.
I think that's correct. The forum was very separate, as you know, from the Commission.
Yes, absolutely, and I'm not saying that you were in charge of the forum or anything like that. The forum failed to reach any consensus in relation to this particular issue.
That's my understanding, yes.
Yeah. Okay, thank you.
Okay. Mr. McCartney.
Thank you very much, Chair. And I think most of the main issues have been teased out, but it's just in terms of your position. I think when you were in your earlier comments, you mentioned this sort of idea. The law should be the theoretical position adopted by the legislator. I think you would only say then sometimes the practical application of it is unclear and coherent, as in this case. Is that your position?
Yeah, no, perhaps I should make it absolutely clear. What I'm saying is what the courts have said in convention terms, and not just in this issue, but on a number of issues, is that where a right is engaged, then that right shouldn't be theoretical or illusory. It should be practical and effective. In other words, which is back to the clarity point. In other words, if there is a right, and in our view, Article 8 is engaged in these terms, then you have to make that right meaningful. So that if, for example, there is a right of physical and psychological integrity of the woman in this case, then the lack of clarity means she and clinicians aren't able to make sure that that right can be enacted in practice. So in other words, we're saying the rights must be effective and practical once they're established. So a kind of a right that you can't actually exercise, that's the issue we're making, with the point we're making. The right must be exercisable in a reasonable way.
And I mean, I know we're dealing today just with the amendment, but in terms of the amendment being, if you like, an extension or a part of the 1861 Act, your position would be that isn't coherent and clear because of the lack of guidelines.
Our position is that legislation as it stands, if you were a clinician, whether you were a clinician in a private clinic or whether actually you were a clinician in in an NGO setting or elsewhere, it's not clear what the parameters are, and this legislation, for the reasons I've outlined, is unclear, that it continues to have a chilling impact because there is a 10-year, up to 10 years imprisonment criminal sanction, and therefore, for those two reasons alone, this amendment, in our view, would be unlawful if enacted.
Okay. And so it's that idea of the sanction and the proportionality and the chill factor run together.
Yes. Yeah.
And in terms of the amendment, would you make any distinction in relation to, notwithstanding the first points you made around the sort of clarity and coherence, in relation to where, in the limited circumstances, there's a termination, the difference between a public health facility and a private health facility? Would you
the point I think I'm making is that there's a recognition that if nobody ever used a private clinic or nobody ever used an NGO service, then clearly there wouldn't be a need for a kind of notion of this kind of amendment, because if nobody was using any of these services, but people do use those services for a whole variety, I suspect, of reasons, and therefore I am sure that some of the reasons why people use those services are perfectly legitimate and proper, and therefore I can't see, I'm struggling to think of any other kind of healthcare treatment where we, for example, decree that you should only go to a public health provision. The private health sector, people can decide to avail of it or not. The NGO sector that provide health services, people can decide to avail of it or not. I'm not sure that we anywhere else in the law are prescriptive and say you must only use a public health facility. So it's an unusual, to put it mildly, amendment that says in these circumstances the attempt is, as far as I can see, to say you must use a public-funded health facility rather than a private facility. So if you choose to go to Accrington Emergency on the Lisburn Road, you're perfectly and pay for it, you're perfectly entitled to do that. Nobody says you must go to the emergency department at Alton-le-Kelvin or the Royal, for example, as a matter of law.
Okay, thank you very much.
All right. I certainly expect a good socialist to want it to be restricted to the public, though. In terms of there being no other decree, is it not fair to say, though, in other European member states, they have decreed that there are certain activities that will only and exclusively be carried out by the state, and that includes the medical? Look at pharmacy, for example. There's member states in Europe, and you cannot dispense pharmaceuticals in France outside of a pharmacy. So therefore you can't get it in a supermarket, you can't get it in a shop, you can only get it in a properly registered, licensed by the state pharmacy. So for you to say it's unusual, that may well be the case, but is it illegal?
I'm not suggesting it's illegal. The point I'm making is it's very unusual.
Yeah.
I have to confess, I'm not as clearly well acquainted with the laws of other European countries and access to their kind of services in a public and a private sphere as you, Chair. But all I'm saying is that, for example, in the UK context, I'm struggling to think of examples where healthcare treatment or provision is confined to the public sector.
Yeah. No, I accept in a UK setting, but for the purposes of European law, European human rights, Northern Ireland's just a region within the European Union, and therefore we can have laws on a Northern Ireland basis. That's why I'm a devolutionist. Don't need to follow slavishly what happens in Westminster. But in terms of the actual amendment, what actually is unclear? You're saying it needs to be clear and practicable, but what is unclear in trying to put into law a provision that says it's only the public sector that can do this? In effect, it's only the NHS. Surely the medical profession, when they read that, will say, absolutely, without a shadow of a doubt, this can't be done in a private clinic, it has to be done in the NHS. There's nowhere in that amendment that I don't think isn't clear. You mightn't agree with it, but surely it's clear. No.
With respect, I'm not sure it is. If we take paragraph 2b, which is the defence that that it's lawful to be involved in an act or an act that ends the life of the unborn child, where it's lawfully performed without fee or reward in circumstances of urgency when access to premises operated by a health and social care trust was not possible. Now, if a person, for whatever reason, if a woman says, I am not prepared to go to a public facility, for whatever reason, I'm not prepared to do that, that's my position, in whatever those circumstances are, for example. And if a clinician who tried to, let's say, persuade somebody, I think you should use a trust facility, I can't. I'm not going to for X or Y reason. If that person then takes the person that they've genuinely made that decision and then takes some action, is that a lawful defence in under 11A 2B? I think the answer is I don't know. If I was the clinician in that position and the person had convinced me, for example, that I'm not prepared to go to a health and social care trust facility, is that sufficient to constitute a lawful defence? I might have a view, you might have a different view. I don't think it's clear as to what the answer would be in those circumstances.
11A 2B is in effect saying, without fee or reward, therefore there should never be a monetary exchange when it comes to ending of the life, and therein another reason why I think it's necessary to restrict it to the NHS, because how can you deal with the perceived conflict of interest, real or not, when there's a financial interest in private service initiatives in respect of this? So that deals with that. Therefore, you can't go to somewhere where you're going to have to pay for it. But say 999 is called, the ambulance is on its way to the hospital, and I can't envisage what circumstance 2B would be necessary. But the ambulance can't get to the hospital in time, and I don't know if they were able to carry out a termination in those circumstances, but in that circumstance, if that was to be carried out, therefore there would be a defence allowed under 11A 2B. It's very difficult to envisage how you couldn't avail of an NHS hospital in these circumstances. I can't imagine one, but this deals with the potential exception that I can't envisage. That's really what 11A 2B is about.
Can I say, I suppose it's interesting, we could kind of have I suppose almost a table tennis match in terms of batting it back and forth. The issue for me is that whether kind of your view or my view is the correct view of 11A 2B, I actually think is neither here nor there. The issue is, if you're a clinician, if it turns out that my view, if eventually it went to court and turned out to be that my view was right or wrong, apart from a kind of I told you so, there's no real set of ramifications for me personally or for you, Chair. If I'm a clinician, on the other hand, and I've got to make a decision about whether in circumstances to do something, and I may face up to 10 years imprisonment as a result of that, then the stakes are very, very different. And so the point I think I'm making is that, interestingly, we have two views about what might be covered by 11A 2, for example. The question is, clinicians have to make decisions that have ramifications for their own liberty, and that's a very different situation.
Although your point is that the prevailing law in Northern Ireland has the chilling effect on clinicians. So whether this amendment is passed or not, the Commission's view is Northern Ireland's law as it stands has a chilling effect for clinicians.
I mean, as you know, the issue of kind of guidance about where we are with the existing law has exercised the courts now on several occasions, and we still, I'm not sure, are in fact, I'm certain actually that we're in a position where there is sufficient clarity about what the position is, and I think that's deeply unsatisfactory. So, yes, I accept that the current situation is not, in my view, clear and unequivocal, and it should be made as clear and unequivocal as possible.
Some might say that it's actually very clear, but there's just been an adverse reaction because it's been so clear, and some don't agree with the law as it is in Northern Ireland.
I would just note that even if you look at the judgments on the guidance issue from 2004, the judges in the Court of Appeal were very clear that there is a lack of clarity here. They also spoke about the impact of penalisation and the criminal effect here. And again, that has been carried through, and it was outlined very clearly by those judges that there is a need for guidance, that there is uncertainty within doctors, within practitioners, and that they were concerned by that. So it's actually something that is a widespread, and they spoke about the fact that judges also felt there was a lack of clarity. So that is actually something that has been since at least 2004.
The difficulty I have,
recognise.
the difficulty I have with the guidance issue is it's guidance of the criminal law. Now you may not want abortion to be regulated by the criminal law. It is, and that always has been in Northern Ireland from 1861. So this amendment deals with the criminal law because that's how abortion is dealt with in Northern Ireland, by the criminal law. The guidance will only ever be a guide to the criminal law. It can't be, and I used the phrase earlier, the Trojan horse when it comes to abortion law. But the guidance can't do that. It has to be dealt with through criminal law. You would accept that?
Yeah. Well, I accept that's the current position that we're in. But when you look back to the Royal College of Midwives and the Royal College of Nursing, as I've said earlier, have made it clear that the current position is unsatisfactory for their members. Whatever their members' views are about the legal position, they need clarity in terms of decisions that they may have to make in carrying out their profession. And they are saying it's unclear. And I have to say, in those circumstances, I understand entirely why that is completely unsatisfactory.
But is it that they're not satisfied in terms of the clarity because they actually just don't like the law?
Well, I can't speak for either the College of Midwives or the College of Nursing in terms of what their position on this is.
I've heard a number of their spokespeople, and they certainly would like a change in the law. There's no question about that. So if the starting position, and herein lies my problem with what the Commissioner is saying, take aside this amendment, the law in Northern Ireland provides a chilling effect. You clearly don't like the law. That's why you're writing to the Department of Justice. You're highlighting issues around rape, fatal abnormalities. You don't like the law, so therefore you're going to be hostile to this amendment from the get-go. Everything's going to be chilling, everything's going to be unclear, because where there's absolute clarity and you don't agree with that, then these are the arguments that are being advanced.
It's not that we don't like the law. That's not how I would characterise it. The question for us as a Commission is, does it meet international human rights standards and the jurisprudence? And our view is that in certain circumstances it doesn't. And that's the position. It's not a matter of whether the Commission likes or doesn't like the law. Dave, I don't know if you wanted to...
We were just going to say that the Commission's role is not to like or dislike. It's to advise the Assembly on compliance with binding human rights standards, and we don't deviate from that. There's no question of what the Commission may or may not like. It's simply the Commission's role to advise the Assembly in accordance with the human rights standards that have been ratified and that bind the Assembly and the Executive.
Yeah, but it's your interpretation of those human rights standards and your interpretation of court's judgments, and all of this is going to be subjective. The Human Rights Commission is not an expert on human rights and is not an authority on human rights. So whenever you're saying the Assembly in compliance with, it's not the Human Rights Commission that would decide that. It ultimately would be the courts who would decide it. When it comes to legislation, it's the Advocate General, it's the Secretary of State, it's the Attorney General. There's nowhere where legislation in Northern Ireland goes to the Human Rights Commission to get a tick box exercise.
Chair, the Human Rights Commission is a national human rights institution established by the agreement. All legislation introduced to the Assembly by statutory requirement is passed to the Human Rights Commission to provide its advice. The Human Rights Commission is considered to be an expert with regards to human rights standards in Northern Ireland, and undoubtedly some issues are justiciable and can be disputed in the courts, but ultimately the Commission has a very formal, functional role to advise this Assembly.
Yeah. So did the Assembly get it wrong when it voted by a majority to pass this amendment?
It's not about whether it got it right or wrong. We have experts.
If there hadn't been the petition of concern, this would be the law.
Well,
so
it may well. I mean, the Assembly is entitled to pass laws. Ultimately, those laws may then be challenged, and it's up to the courts to decide. It won't be. You're quite right in the sense of, for example, if this law was passed, and if the Commission couldn't strike down this amendment, if you decided, the Department of Justice decided to to implement it. We or somebody else might well decide to take a legal action, and then ultimately it would be for the courts to decide. And it would be a matter then for the courts. So to the extent that you're saying, I mean, I think the Commission is a national human rights institution. It does have a role. It's been accepted in terms of the 1998 Northern Ireland Act that we have statutory duties and powers. And I think there's a recognition in terms of then the Paris Principles about the pluralism of the Commission, that it's expected to have expertise in areas of human rights, and I think we have that. But we don't have a monopoly of wisdom in the sense of that everything we say will automatically be followed by the courts, any more than anything that the Assembly enacts will automatically be upheld by the courts. It would be a matter for a legal challenge and for the courts to decide. That's the role of the courts. They're independent of the executive. It's not for us, other than for us to ask the courts as to whether something is lawful or not, and the courts.
Finally, in terms of the correspondence with the Department of Justice, is the Commission in threatening potential legal action in respect of these issues?
Yeah, we are considering legal action on those issues, yes.
Do you not think it should be a matter for the Northern Ireland Assembly to deal with, rather than the Human Rights Commission usurping the democratic responsibilities that we have on behalf of the people?
I don't think our role is to usurp the role of the Assembly. Our role is to examine human rights international standards and laws and decide whether, and to offer advice in circumstances about, and we've offered that advice to the Department of Justice. It's then up to the Department of Justice whether to take on board that advice, and I think it's within our statutory remit, if we choose to ask the courts to decide, and that's almost certainly what will happen on the kind of issues in the correspondence that we've had with the Department of Justice.
So David Ford might as well put his consultation in the bin, because what's the point in having a consultation? What's the point in seeking legislation through the Assembly? The Human Rights Commission are just going to bypass the Assembly and go to the courts. Or if the Assembly rejects what David Ford wants to do, you're not going to respect the will of the Assembly. You're going to go to the courts.
No.
You're exactly usurping the democratic mandate that elected politicians have to deal with these issues.
With great respect, our role is to uphold and to offer advice and to as to when international human rights standards are met. If the Assembly chooses not to meet those international human rights standards, I think it's perfectly proper. I don't think it's not something that would be done lightly by the Commission. It's perfectly proper for the Commission to consider legally challenging if a democratically elected body, and I have great respect for the democratically elected body that's the Assembly, if it chooses, in our view, to breach international human rights standards and jurisprudence, I think it's perfectly proper for us to ask the courts to adjudicate on that matter. We're not seeking to, in some way, traduce the democratic mandate that the Assembly has, but our mandate is to promote and protect human rights. And I think that we would be not doing our job, frankly, if we didn't do that.
Well, there's no point in me repeating what I've said earlier, because I take exactly the same view I did a couple of minutes ago about your threatened legal action, which, to be honest, I find astounding. I find it astounding that at the time that there's a consultation exercise that's being commissioned by the department, the Human Rights Commission have decided we're going to put in a letter, we're going to threaten legal action whenever there's a public consultation, when politicians will have to deal with this. The Human Rights Commission are behind the scenes, pulling the strings and threatening legal action. I just find that utterly unacceptable, that the Commission would conduct itself in that manner. I really do. It undermines what David Ford is doing, and it undermines the authority of this Assembly to be able to deal with it, because, in effect, what you're saying, if the Assembly doesn't deal with it in the way you believe it should be dealt with, then you're going to go to court and try and bypass this Assembly. Now, I'm repeating myself again. It's the same point, but I do find it astounding that the Commission has acted in the way that it has.
And I can repeat, and I'll be very succinct. The Commission's role is to uphold and protect and promote human rights. It's within the international framework. It's a framework not set by the Human Rights Commission. It's set by international treaties that have been ratified by the UK government, and therefore these are not standards or something that have been set up by the Human Rights Commission. They're international standards that have been signed up to by the UK government. And part of our role is to promote and protect those rights, and that's what we will do.
Mr McGlone.
Yep. Thanks very much, Mr. Chair. And I have just 2 points. I'll be very brief on them as long as you're right. In paragraph 46 here of your submission, it just says, this in regard to the proposed amendment. The Commission notes that the restriction amendment may be read as being so broad as to include certain forms of contraception which are legally available in Northern Ireland. It's just, could you elaborate on what that means, what types of contraception, please, just for my own clarity of purpose?
Well, and my colleagues on that. One example, for example, is the morning after pill.
Right.
As far as I can see, this amendment is so widely drawn that certain forms of contraception that are perfectly lawfully available in Northern Ireland, that administering or distributing those could be contrary to this amendment. I'm not suggesting that that's what it's intended to do, but it could be interpreted in a way that...
Okay, thanks for that. Now, I'm taking you back to something you said earlier there. In regard to 10.2, the right to life, paragraph 53 of your submission, that's taking the appropriate steps to ensure the patient's lives are protected. Now, and I was listening very carefully to what you were saying earlier about the rights of the fetus or the pre-birth child and the mother are inextricably linked. That brings me back in your interpretation of what the interpretation is. Is the pre-birth child a patient? If they're inextricably linked, their rights are inextricably linked then.
I suppose the first thing to say, it's not my interpretation. What we've said to you this afternoon in our submission is it's the interpretation.
No, absolutely. Well, your articulation of the interpretation, maybe I should
of
say
human
that.
rights,
Okay.
and I've attempted to be, it's kind of fair-minded and measured as
Yes.
objective about what the courts have said. It's not my or the Commission's particular interpretation. Yes. It's what the courts have said, and I'm keen to kind of stick to that. I'm not sure that I kind of know what the answer of whether an unborn child is a patient or not. I don't think it's an issue that I can fall back on and say the court has considered this and here's the answer to this.
No, well, then that's fair enough. It's just that it was the positive obligations imposed on the state by Article 2 of the Convention imply that a regulatory structure be set up requiring that hospitals, be they private or public, take appropriate steps to ensure that patients' lives are protected. And it was whenever you said that the rights of fetus or the pre-birth child and the mother are inextricably linked, and everything that had been said before in your document around the rights of the mother, I was just seeking some sort of clarity if you knew, or if there was something, or perhaps you want to come back to us if there is something in international law which does expand upon that or clarifies that.
We could look at it and come back, but without having, I think the short answer is you've asked a legal question that probably hasn't been considered by the courts.
Right, okay.
Well, I mean, I can speak specifically to the quote that you're referring to, and that quote is actually it's a case where what happened was that the mother died and the fetus died. So that was where the court, which is what the Chief Commissioner read the quote from earlier, and the court looked at the situation of the fetus because they were asking about Article 2 rights for the fetus in that situation. And the court held that that was not something that they needed to consider at that time. So that was in that particular case.
Yes.
And in this context, in terms of the right to life, the issue is whether this amendment is actually clear enough in order to ensure protection for circumstances where a woman's life may be endangered, and that additional threat of prosecution in circumstances
But
where...
I understand here entirely where you're coming from. I understand that. But it's where the rights of the fetus, the pre-birth child, are inextricably linked with those of the mother. and then the interpretation of the patient's lives are protected. And I note the plural is used there as well. So,
As I understand the position, if you look at the issue of, to use the phrase, the patient, you can't, and the court has never, in terms of Article 2 and the right to life, said there is a separate, if you look at separately the right of the mother and the right of the unborn child. They're
Yes.
inextricably linked.
Yes.
So in terms of whether kind of the unborn child has a separate right based on being a patient, I think the answer to that question is, on the basis of the jurisprudence of the European Court, is no, in my view.
well then, why did they use plural instead of to ensure that the patient's life? That to me is taking us into a different area, and you're the legal people. Maybe you'd best want to come back on that if there is some sort of legal definition or legal.
We can certainly come back, but earlier when we talked about the margin of appreciation and the restrictions that can be put legitimately by the state upon access to termination of pregnancy, the state may well be restricting access to termination of pregnancy in order to protect and provide domestic protections for the unborn child. So there is a balance there in terms of what will be getting protected by the domestic law.
Yes.
And clinicians may well have a view, for example, here with regard to patients.
In that particular case, and I don't know why the word patients with an apostrophe after it was used, but in the case it did actually look at it, said, the court said it considers that the life of the fetus in question was intimately connected with that of Mrs. Senturk,
Yes.
and depended on the care provided to her. So I don't think, in the particular case which this quote comes from, there is a separate assessment of, in this case, this was a child that was being carried that actually they knew was not going to come to term and was going to, there was a lethal malformation. So I don't think the courts were saying that there are two separate sets of rights recognised in Article 2.
No,
there remains the position that they are
But
inextricably
what
linked.
I'm not talking about two separate sets. I'm talking about what appears to me from the logic of what them being inextricably linked, and then, to my simple mind, the use of the plural there again is coexisting rights linked between mother and child. So, but anyway, you may well want to clarify. It's just as you spoke, and as I'd read it last night, I was.
Sure.
You may want to clarify that if there is any previous law around that. It may well not be, but it has been raised as an issue just today here.
Well, I think I can provide a little bit more clarity for you. Basically, this quote, so what usually happens in the European Court of Human Rights judgments is that you have a set of general principles which are set out the requirements on the state. So this is one of those general principles where all of the patients who come to these private and public hospitals have to be protected in this way. So the regulatory system has to be set up. So this is setting out the general principles. That general principle is at that part of the judgment, and then later on, those principles are applied to the particular case. So that's not actually particularly relating to that issue. It's simply all patients.
But you do agree it raises a bit of an anomaly in terms of interpretation? It can do, depending on the context in which you read it. As I read it last night, because I wasn't reading the rest of the case.
Right.
I'm not sure if you read the rest of the case that it does.
Well, maybe so, but
I'm happy to take it away
if
and
you
have a
can,
look at the
please.
issue if that's,
All right, thanks,
that's
Chair.
helpful.
Okay,
Thank you.
thanks, Patsy.
Thank you.
Mr. Dixon?
Thank you, Chair. Chair, can I just perhaps at the outset say that I wholly value the role that the Human Rights Commission plays in Northern Ireland in respect of its relationship with this establishment, and it is important that you exist, and it is important that this Assembly recognises the role that you have to play in doing that. And I certainly recognise your role in being an appropriate body under the legislation to provide us with the advice and guidance and concerns which you have in respect of this and many other matters. Can we turn specifically to the issue of the morning after pill? And the concerns that you have, that this amendment would have the potential to widen the net to include the morning after pill. I just want to sort of test how realistic you believe that is. Is that a scaremongering tactic on your behalf? Or do you have a genuine and real concern? And what would be the effects of that? Could we find an organisation who might feel that the morning after pill is a step too far, taking a legal action against someone who either prescribes it or indeed the person who hands it over the chemist counter?
Yeah. I don't think it's scaremongering. I think what we're saying is that this amendment, as drafted, allows someone, if they wish to, for whatever reason, to say that on the basis of this drafting of this amendment, to take a legal challenge against somebody who was providing access to the morning after pill. I don't think that's scaremongering. I don't think that the intent of this particular amendment is to do that, to use the Trojan horse analogy. I don't think it's a Trojan horse for that particular purpose. That doesn't mean it couldn't happen. That's where our concern is. I don't think that's scaremongering. I think that's a genuine objective assessment.
And it's not unreasonable to suggest that there are those organisations out there who would wish to take that type of action. And even though this is not a Trojan horse, and the proposer is not suggesting that as a part of the amendment, nevertheless there are those out there who could draw on that and pursue the matter.
Well, we would certainly refer to, for example, the Smeaton case, which was a 2002 case in England, which actually tried to make that argument in terms of the morning or after pill, and arguing that it in fact fell under the 1861 Act, which the court in that case felt that it didn't, and held, they didn't succeed. But it is certainly the case that, as you point out, there are organisations who would take such a case. And furthermore, the issue is that the language that's used in this amendment, the life of an unborn child at any stage of that child's development, it's not language that's actually used in the existing legislation, and it's not language that's been considered. So that argument could potentially be made.
So we're not, in a sense, even debating what we have debated for some time around this table, the issue of when life begins and things like that. It is quite simply at any stage, and at any stage has to be at the point where someone knows that they are either pregnant or likely to be pregnant and take the morning after pill.
Yeah, I think what we're saying is that it leaves open that potential. It has the potential for that kind of challenge. It's drafted in a way, and it may not be its intent, and where that kind of challenge would be open to someone or an organisation to take. It's drawn very, very widely indeed.
Can I then take you back to the other point which you referenced, which was the actions of a clinician acting outside the health service in dealing with a situation? And you painted the scenario where the individual refused or did not wish under any circumstances to use a health service facility. And the clinician is then torn between, do I act and break the law, or potentially break the law, or do I act and not take a fee in hope that that will protect me, but I've done it on premises which aren't prescribed, and all those doubts, the chill factor it's referred to. And I understand the concern that could cause. But the question is this: what happens if the clinician says, and I'm sorry, I really cannot help you, I'm refusing, I will not help you in these circumstances, there's only one place you can go to, and that is to a health service facility. And remembering that the areas that permit this can include the mental state of the mother. In those circumstances, if the mental state of the mother led her to walk out of that advice and commit suicide, or simply to refuse any further treatment, what effect could that have on the clinician who refused?
Well, it's interesting that in at least one of the Polish cases, for example, the question was around, there was a statutory law, and the question was around how, if you like, clinicians treated the individual in those circumstances, and whether, I mean, ultimately there was a set of kind of professional ramifications as a result of not providing treatment in a way that allowed the termination in the circumstances within the Polish law. It seems to me that you have to have the wisdom of Solomon as a clinician in this kind of case to decide, what am I expected to do in these circumstances? And it seems to me that that's an unfair burden to place on a clinician who may have to make an extremely difficult decision with ramifications that that person can't foresee. It doesn't seem to me, and then, as I said earlier, to be particularly satisfactory. And in terms of back to the jurisprudence of the European Convention, I don't see how this amendment meets the notion of clarity and proportionality, bearing in mind, again, Article 8, in our view, is engaged in this case.
And on the one hand, the clinician is left open to legal action if they do take action, and if they refuse and there are fatal consequences as a result of their refusal, could the survivors or family take legal action against that clinician?
In terms
of the refusal?
Of the refusal, the question, I think, might become whether that person was individually liable or the state was liable. But
yes, indeed, could the state be liable as well?
Yeah, I think the answer is that there are some positive obligations that are imposed on the state, and therefore, yes, there would be legal consequences in those circumstances. And it's in our submission where I think, again, we've quoted in the Centre case that the positive obligations imposed on the state by Article 2 imply that a regulatory structure be set up requiring hospitals, private or public, take appropriate steps to ensure patients' lives are protected. So one has to act within the law, in my view, in terms of the legal position, and when the criminal law applies, bearing in mind the common law situation, it's not currently clear.
Thank you very much.
Yeah, thank you.
Mr. Fruit?
Yeah, thank you, Chair. Around your argument around the morning after pill, again, with it not being on the face of the amendment, you could argue that that's basically pure speculation on your point, on your part. And having said that, and listening to your commentary, we've been told that human rights do not apply to the unborn child. What's your commentary on that?
Well, I don't think human rights don't apply to the unborn child. It is an accurate characterisation of the position. Our understanding of the position of the Convention in Article 2, as it's been interpreted by the Court, is that the human rights of an unborn child and a mother are inextricably linked. The issue is one in which there is a margin of appreciation in terms of how the states deal with this matter. But once you set some provisions, whether in common law or statute, that there is circumstances in which a termination is lawful, then it must be effectively regulated to make that right effective and not illusory, because it engages rights in the Convention. But what the Court hasn't done is made clear exactly what the rights of the unborn child are in terms of the Convention.
And what's your commentary on that then? The fact that it is unclear?
Well, I think the Court has taken the view that there is not a consensus across the contracting states and as to the issue. That they've made clear that the majority, the substantial majority of Council of Europe members have got some statutory provision for abortion, but nonetheless a consensus about when the rights commence in terms of an unborn child. There is not a consensus, and they are not prepared to effectively make that decision in the absence of a broad consensus. And kind of what I think about that is, I think it's probably neither, or the Commission think about neither, not here nor there. I think our role is simply to articulate what the current position is. That is the position.
But yet the Commission would see fit to challenge this government and the actions and the laws that they would pass, but yet you won't challenge or make comment other than to say that it's neither here nor there when it comes to the rights of an unborn child.
Yeah, I understand it. I mean, if there is to be a challenge, then it's likely to be under Articles 3 and 8 and 14. All I think we've offered our advice to the Department of Justice. The Department of Justice is perfectly entitled to accept or reject that advice. If we think it's in breach of human rights law, then in terms of our statutory position, then we are entitled, I think, as a Commission, to make a judgment that that should be clarified by the courts.
But you would have a right to comment. Do you have a right to challenge?
Well, we do have a right to take legal action. It clearly must be where we genuinely believe there's been a breach of human rights law, and that's what we genuinely believe. Ultimately, it'll be a matter for the courts to decide.
This may sound like an oxymoron, but what human rights does a dead person have?
I'm not sure. Well, there are a set of issues about other immediate family issues. I don't have a kind of obvious and pat answer to what the human rights of a dead person. I'd actually need to go away and reflect, frankly, on that. And I think if I tried to extemporise on that, I don't think that would probably be helpful.
Would something like the rights to a burial, rights to be treated with respect,
Yeah.
is that the sort of thing?
The rights transfer to the next of kin.
Yeah. You might engage family members in terms of a right to a burial as opposed to the dead person.
Yeah.
There might be a set of issues about the person's wife or husband or partner, for example, rather than the individual who has died.
Well, why I ask the question, I suppose, is do you have any concerns as a Commission for the treatment of the child after the abortion?
The court, we just go back to that initial judgment that Les has said about the rights of an unborn child, the rights of the mother. In this instance now that you're highlighting here, it's the Article 8 rights of the mother that are engaged.
So really there is no rights of the child in the womb?
No.
Or after the event of an abortion?
Yeah. Post-abortion, I think the rights of the unborn child are inextricably linked with the rights of the mother. What the court has said is you cannot decouple those rights. They're not separate rights, they are interlinked. So I don't think it's accurate to say the unborn child has no rights whatsoever. I don't think that's what the court has said. But it's not a separate right, separate from the right of the mother. I don't think the court has ever gone to that extent. And I think actually that's reflected in domestic court judgments as well.
And there is issues in public policy that have obviously been in outside of human rights law in terms of retention of organs and such things that are a result of medical procedures, and they've been well versed in the UK. Not clear offhand, but have to consider whether there were human rights matters brought to bear in those cases or not. But certainly there's Article 8 rights of parents, family members engaged when it comes to a death, regardless of where that may be, whether it's a child or an adult.
And again, I ask this genuinely because I don't know, Chair, but is the child after an abortion a dead person?
you're asking a straight legal question now rather than a human rights matter. We'd have to go away and look at what the law says.
I don't know in legal terms, you know, I could speculate, but I don't actually think it's helpful. And if it would be useful, I'm quite happy to go away and write to the committee, you know, kind of more considered view.
I think that would be useful, Chair. Thank you.
Could I just make one point in relation to that? The Attorney-General for Northern Ireland and Siobhan Desmond, in that case against the Senior Coroner for Northern Ireland, the Court of Appeal allowed an appeal by the Attorney-General and ruled that the coroner can carry out an inquest into the death of a stillborn child that had been capable of being born. Now, in other words, the personhood was given to the stillborn child. So it's a very interesting question that Mr. Frew raises, whether or not an aborted child has personhood or could acquire personhood in the way the Court of Appeal gave a stillborn baby personhood. And of course it's interesting that in our own legislation that the baby, I'll use that term, in the womb is referred to as a child, which is a significant statement in terms of legislation. Perhaps you could explore that whenever you come back to the committee in relation to it, because it is a very important issue. And the other point I would just make is, you know, rights do develop. And I mean, in the middle of the 19th century, slaves were slaves. They had no rights. And then, of course, they were granted the right to be people, citizens. Is there not an evolving situation could there not be an evolving situation in the jurisprudence of the European Court that could lead to a situation where you have that separation between mother and child and in the womb, and that rights could be acquired by the fetus?
I'm not sure there's great value in me trying to speculate where, in terms of a living instrument, this issue will go next. But yes. I'm familiar with the kind of Attorney General's challenge to the coroner. I haven't got the Court of Appeal decision here. I think it would make much more sense for us to go away and give you something more considered, and I'm happy to do that. And I think that probably is the right way to address the point made by Paul Frew.
Thank you. Thank you, Chair.
Mr. Pudge.
Yeah, I think at the outset, sure, I'd comment that we get less evasiveness from our ministers than we're getting from Mr. Allenby today, and it really isn't conducive to actually getting to the crux of the issues here and dealing with the issue in an appropriate way. So, you know, the benefits of Mr. Allenby coming here and dancing around on the head of a pin as opposed to actually trying to answer questions actually limits any real benefit there is, tangible benefits there is what's been coming to the committee to give evidence in the first instance, and perhaps they reflect on that afterwards. In terms of the evidence we received last week from Amnesty International and their views of human rights law, they were very clear that the unborn child or the fetus had no rights until it was born. Do you have a different interpretation of human rights law than Amnesty in that instance?
Well, I think what we've done today is set out our understanding of the legal position from the European Court. I'm not in a position to comment on Amnesty International's evidence. I haven't heard it or read it. So our position is our view as to what the position is in law based on the jurisprudence of the court.
Which is the unborn child has rights, but they're associated with the rights of the mother.
They're inextricably linked with the rights of the mother, yes.
But they have no independent rights?
in our view, in looking at the jurisprudence of the court, they don't have a separate existence. That's our understanding of the law, and I think that's reflected in both domestic law and international law, yes.
Okay, so there was a case in the United States where cancer was identified on the lip of an unborn child, and they were able to remove that cancer pre-birth. Would a child in that circumstance, an unborn child in that circumstance, here in Northern Ireland, be entitled to that sort of care from the health service?
Off the top of my head, I don't think I can give you a satisfaction. I'd have to go away and reflect on that. Yeah.
Well, just to be, just to try and,
The Human Rights Commission are here to answer in this amendment.
could I?
And I have to say, we've been very liberal with our question and up to date, but if people are coming here briefed to talk about a particular clause and an amendment, they ask them questions that they're not briefed on. I think they're being honest and they don't know.
I think that in relation to this amendment, it is about unborn children.
Yeah.
And in fairness,
No, it's where not a certain aspect of the law can be extended.
Yes.
Prohibit something happening within a private clinic.
So we're
It's nothing to
sticking
do with the rights. Nothing to do with the rights of the unborn child. That might be for an hour day and an hour debate, and I have no issue with it. But the day people come into the committee to talk about a particular clause and then ask questions. Now, Paul Frew asked legitimate questions. I think it was given a considered answer will come back. But I think, in fairness, you can't accuse people of not answering questions if they're not here briefed to answer.
Sir, if I could
in
maybe.
fairness, the Commission did talk quite widely around the issue of abortion and setting the context, and then moved on to this amendment. So there's an element of they have invited a much broader discussion by their opening remarks.
And fair enough, and that has been teased out, and that's acceptable. But they say that people are being evasive when they say we'll come back with an answer. I think it's a bit unfair, to be quite fair.
I think somebody wants.
All I wanted to say was you're raising an issue and you're using the language of rights, and where the state may choose to provide a service and where a mother may choose to avail of a service as an entitlement provided by the state to make an intervention to save the life, in this instance in America that you're using, of the unborn child, is a perfectly legitimate action by the state and service to provide, whether that's a human rights matter as opposed to a protection of the rights of the mother and the unborn child by the state. The two things aren't necessarily coterminous, and that's not to say that the entitlement wouldn't exist.
So, well, perhaps it's something that you would reflect on if unborn children have a right to healthcare.
No, I think the position is quite clear. We can only keep referring back to the European Court's jurisprudence, which we cannot step outside. We'd be outside of our statutory remit, that the rights of an unborn child are coterminous and inextricably linked to the rights of the mother. Service provision by the state in protecting an unborn child and what services may or may not be provided fall within the margin of appreciation of the state and its health service.
And does a mother's reproductive rights always stump the rights of the unborn child?
Well, clearly not, because the European Court recognises that it's within the margin of appreciation to regulate access to termination of pregnancy.
Okay. And in terms of this issue about the morning after pill, and you raised it yourselves, when do you know a child is conceived? When do you first know the child is actually conceived?
I'm not sure that the law sets out. I mean, the issue of different states have in statute set out what they consider in a statutory basis. In the absence of a statutory basis, I don't think there is, as I understand the jurisprudence of the European Court, there is something that establishes that issue. The courts have said that there is not a consensus about that, either a legal or a kind of legal or legislative consensus around that, and the court is not prepared to enter into giving a definitive version.
So
That's the legal position.
If I was to take a challenge, walked into court, 3, 4, 5 days after someone had taken the morning after pill, and 3, 4, or 5 days after, what standing would that have? How could I prove that that person was pregnant in the first instance?
In Northern Ireland?
Yes.
Well, under the current legislation, the Smeaton case in England would actually be informative in that case, because under the current legislation, they held that the morning after pill is not prohibited. So that's why I was pointing out the difference between the language of the proposed amendment and the language of the current legislation, which actually there is some clarity on. Because
how do I prove the individual was pregnant? If I decided to take a case, how do I prove the individual was ever pregnant?
Well, if you look at that case, the Smeaton case that I'm referring to, they actually went into great lengths in looking at the scientific and the legal issues around that. And the reason why, again, there's a significance in the difference of the languages, because one of the points that they talked about was the miscarriage, which is in the 1861 Act. That's not in the existing legislation. That's why it's a distinction.
So the morning after pill is in essence a contraceptive method. Isn't a means of termination of itself?
Yes, but
and it's fundamental. You've raised an issue that someone could end up in court over this. I've asked you a very simple question. If I'm standing in a court of law, how do I prove that someone who took the morning after pill 3, 4, 5 days after they engaged in sexual intercourse were pregnant in the first place? And therefore, how could I actually bring any challenge in any court of law in that instance? This is a straw man.
Well, with respect, the Smeaton case was taken by, on behalf, I recall, of an organisation, and an organisation took the case on the basis of that the morning after pill was, that the administration of that was unlawful. So it wasn't taken by a particular individual, or it was taken on behalf. I think there was an organisation joined. If I remember, it was taken by an individual on behalf of the Society for the Protection of Unborn Children. So the person who took the case didn't take it on the basis of what had happened to that person as an individual. They took it on behalf of an organisation. And the point we're back to making is that the amendment is not clear. And if an organisation, as opposed to an individual, wished to take a case on the basis of this amendment, in our view, they could do that. They'd have to prove they had standing and sufficient interest, etc., etc. But they could do that. They wouldn't necessarily need to produce an individual in order to do that.
They'd have to prove pregnancy.
Well, no, they could.
You couldn't go to court on the basis that a pregnancy was terminated wrongfully if you couldn't prove that there was a pregnancy in the first instance. In which case that would be a misuse of the morning after pill.
But that's not the purpose of what this amendment is seeking to do.
You've raised this.
Yeah, but all we're saying is that this amendment doesn't provide clarity in terms of what it is, what it does, that it can be interpreted in a way that goes beyond what its intent appears to be.
But when it's linked to other law and good practice, I think the clarity is sufficient.
I beg to differ. That's fine. I understand the point you're making. I understand. You
beg to differ, but you haven't demonstrated how it could be done.
Yeah.
Just, Mr. Poots, the language that you're using is termination of pregnancy. The language of the amendment specifically says ends the life of an unborn child at any stage of that child's development. That's a different set of language. So the language you're using that you're saying needs to be proven in court is actually not what the amendment is requiring, and is not the offence that the amendment is actually establishing or is seeking to establish.
No.
So this is why we're saying that that is not clear.
Either you're not getting what I'm saying, or you don't wish to get what I'm saying. What I'm saying very clearly is that for any individual to take this matter to court, they would have to demonstrate in an unequivocal way that conception had taken place in the first instance. And how does the individual do it? Therefore, this is purely a scare tactic on the part of the Human Rights Commission, as opposed to a real threat.
No, I'm really sorry, but no, it isn't. And I'll go back to the A, B, and C case, for example, which dealt with the 1861 Act. And one of the points it made in its judgment was that even where there was such a lack of clarity in terms of the regulatory framework and how things applied in the Ireland case, even if in reality prosecutions weren't happening, the lack of clarity was still sufficient for it to be contrary to the convention. So even if in this case, whether somebody decides to prosecute or take a case or otherwise, the lack of clarity. And in the way that this is framed, it is so broadly framed in terms of, as the point was made by Ciara, in our view, this amendment would be contrary to the convention. Now, I accept that people around this table may have a very different legal view. This is it's the Commission's view based on stepping back and looking at the jurisprudence. I understand that others may take a different view, and that's fine. And that's perfectly, normal and understandable. And ultimately, if it came to a challenge, the courts would have to decide. But it's a view that's based on international human rights law. It's not based on some kind of, if you like, commission crusade or anything else. It's based on our understanding of the jurisprudence.
I'd be generous and say your arguments are tenuous at best. In respect of this, Chairman, the only threat in regards to court isn't coming from anybody in this issue. The threat to go to court is actually coming from the Commission themselves. Whenever policy is being devised, the Commission are threatening to take people to court, not for the first time, and that is an inappropriate action on the part of the Commission. If this Assembly makes a decision which isn't compliant with human rights, you are very well entitled to challenge that. But when this Assembly is making law and devising law, it is your job to lobby, not to be threatening court action. And I think that is something that the Commission really needs to reflect on, because one would consider it to be bully boy tactics.
Chair, with great, and Edward, with great respect, it's not our job to lobby, it's our job to advise.
Yeah,
and I don't see our role in this issue as about lobbying. It's about offering advice. And that advice is genuinely given, based, as I've said before, on the jurisprudence, and it's up to then a government department or to this committee whether to accept or reject that advice. I understand that, but it's not our job to lobby. It's our job to advise.
Fair enough. It's your job to advise, but it's not to advise with the threat of court actions in the midst of policy in the making.
I understand the point you're making.
It's anti-democratic, to be quite frank.
Yeah, well, for us, the issue is whether there is a breach of human rights law, and in terms of international standards, those are standards that have been signed up to by the UK government. I understand the point you made, and the Chair made it equally forcefully. I understand the...
For us, we cherish democracy and the right of the people's voice to be heard through elected representation.
And part of democracy includes safeguards and checks and balances, of which there are many, and the Commission plays a small part in that. And I cherish that democracy with checks and balances equally as strongly as you and your colleagues around the table.
Thank you, Chair.
In terms of the wording, unborn child at any stage, set aside that some of us won't accept
Yes.
your interpretation of it. What if it read of an unborn child from implantation in the womb?
Yeah.
Is that given the clarity? Because at that point, you will know if you're pregnant. That can be unequivocally demonstrated through whatever tests are done. Would that deal with the lack of clarity?
Yeah. To be candid, I don't think it's for me as the Chief Commissioner commence a kind of negotiation here this afternoon. If there were other forms of wording that were being put forward, what I'd want to do is go back to the Commission, talk to my colleagues, reflect on the issues, and then come back to you, because I don't think it's appropriate for me as the individual. I'm only one of 8 commissioners, and I speak on behalf of the Commission, not on behalf of me as an individual. So I don't think, frankly, it would be right for me to start negotiating one way or another as to what is the Commission's position based on something that might look very different from this amendment. If there's another amendment is suggested, I will happily take on a collegiate basis the Commission's view.
And then in terms of 2B, if that's the area where you're not clear on, 2B is actually meant to be helpful in the unexceptional cases of urgency. But if it creates uncertainty, remove 2B and then leave 2A. And surely it's absolutely crystal clear that the act or acts of ending the life of an unborn child lawfully performed at premises operated by Health and Social Care Trust. So, for the sake of clarity, let's remove the exceptionality aspect of this, which is actually trying to be helpful, but let's remove that. At least now you're absolutely clear.
Well, for the same reason I've outlined just now, I'm not sure it's for me to kind of negotiate a solution. For me as an individual, I speak on behalf of the Commission, and I don't think it's appropriate for me this afternoon to try and craft something and give a view on behalf of the Commission. I have 7 other commissioners, and I'm sure they might want to reflect on any different amendment that was in the Justice Bill. And that's not about being evasive, that's just about proper corporate responsibility.
Yeah, no, I'm just trying to establish, because if it's not about the principle behind this, that's a matter for the state within the margin of appreciation. It's not about the principle, it's just about the clarity. Then we could be actually very clear. Now, in my view, it would make it worse. But it could be very clear by stripping out 2B.
Yeah. The position for the Commission is, does any amendment breach international human rights law based on the jurisprudence and the standards, and we'd look at it on that basis. So if there was an alternative amendment, we would reflect on that and come back to you. And if the view was that that it was no longer, in our view, a breach of the Convention, then we would say that. If we felt it still was, then equally
we
we'd
know
have to
the
set out
answer.
the reasons why.
We know what the answer will be then, because existing law is in breach of, in your view, international law. So there's really not much point talking about the amendment, because existing law doesn't meet the standard. So what this does is regulate within the existing law. Your problem is you're not happy with existing law. So,
Sorry, Chair. The amendment deals with the provision of a service and where it may be performed and where it may not be performed. That's entirely different from the issue that you raise with regards to the criminal law and whether it's compliant with human rights law or not. An amendment could be introduced, amendment could be drafted or changed in such a way where the amendment in and of itself, regardless of the wider issue, may be in compliance with convention law and international standards. And the Commission would look at that independently, as we always do with anything that comes before the Commission, and give our considered advice.
do you think, in the interests of social cohesion, it's better that parliaments deal with these sensitive social matters, which is what it is, or for the courts? You take the 1967 Act, which I disagree with, and I think everyone actually in this committee disagrees with, but it was brought in by politicians, mandated by the people. I may not agree with that decision, in fact I don't, but as a Democrat I have to accept it. If you take the issue of gay marriage, again I disagree with the vote in Parliament, but it was a vote by politicians mandated by the people. It wasn't brought in by the courts. So therefore, as a Democrat, I have to accept that. However, when the courts become responsible for ultimately dealing with sensitive social issues, do you think that is a good way for social cohesiveness or a bad way for social cohesiveness?
In terms of social cohesion, I believe in parliamentary democracy, and I believe in the split between the executive and the judiciary, and I accept that there will therefore be, that Parliament is entitled to pass laws, devolved assemblies are entitled to pass laws, and the question of whether those laws are lawful, whether it's in terms of human rights standards or administrative law or anything else, is a matter for the judiciary. And I think that is a perfectly proper check and balance, and one that I would support. So in terms of social cohesion, I don't simply look in a narrow sense in terms of parliamentary democracy. I look at the broader sense of checks and balances, and I would support that broader conception of checks and balances. And I would be utterly respectful of the rights of parliamentarians to pass laws. The question of whether those laws, if you like, stand up to judicial scrutiny, then becomes a matter for the courts. And that seems to me to be perfectly proper, and I'm not seeking in any way, shape or form to undermine that form of democratic accountability.
Mr Douglas.
Thank you, Chair. Les, someone asked you earlier on about the Amnesty International, and you said you can't speak for them. They made a submission to us and it asked us, and it made a claim about human rights standards. So could I ask you what your interpretation of this is, but also does the Commission believe that this comment? And it says that human rights standards are clear that access to abortion should not be hindered, should be easily accessible and of good quality, and that states should eliminate, not introduce, barriers which prejudice access to abortion services, such as conditioning access to hospital authorities.
Well, I think as a statement of kind of Amnesty's view of how policy should be provided, I don't demur from Amnesty's view on that. In terms of whether the law requires policy to be implemented in exactly that form, I don't recognise that in terms of a particular quote from a judgment. But in terms of the principle of where abortion is lawful, should the regulatory framework be clear so that everybody knows in terms of their position, the clinicians, the woman, and the inextricable links linked with the unborn child should be clear about what the law is, then I think that is the position that the Commission takes on this matter. Kind of whether I would frame it in terms of the way that Amnesty has framed it or otherwise, I don't think is the issue for us. That's the position. That's our understanding of the kind of court position of this, and that's the position that we're seeking to uphold here.
And come back to the thing about the clinicians, and you talked about the chilling factor.
Yes.
You also mentioned malformation, sexual crimes, including rape and incest. And I think you want to say that the right to an abortion and some or all of those circumstances is clear. And again, let's go back to Adam had raised a question last week with Amnesty, and I'd asked them, at what point can someone have an abortion? Is it 15 weeks, 20 weeks, whatever? And the reason I'm asking that is that if you feel that, or what's your view on is it full-term abortion in some of these circumstances, and what rights would, in terms of the whole chilling factor, have, say, for a doctor who has to perform an abortion at say, 37, 38 weeks, whatever?
I think what we're saying is that in the circumstances of a victim of sexual crime or a serious malformation, that there should be a clear, the termination should be available in those circumstances. It should be clear. I don't think we're starting from a position of saying exactly at what point it should be clear. It should be, again, there is a margin of appreciation here that the state has in these circumstances. It should be a right that's real and practical and not theoretical and illusory. Now, where you draw the line within that is a matter for the state. And again, if it's drawn in a line that is far too restrictive, then I think there's a set of issues there. So I don't think, again, it's for the Commission to say exactly at what point, what number of weeks it would be, but it needs to be, the right needs to be real and practical.
I think what Amnesty International were clearly saying that the rights of the mother were paramount in that, no matter how long the pregnancy lasted. But you're not saying that.
Well, we're saying again that the right is inextricably
The
linked.
paramountcy test would only apply under the right to life.
Yeah.
Yes.
And then in the instance where the mother's life was clearly at risk,
Yes.
that would be a paramount concern. In all other instances, whether it would be serious malformation of the fetus, rape, incest, sexual crime, it falls within the margin of appreciation of the state to determine where that line should be drawn in the sand.
Okay, thanks very much. Thank you, Chair.
What I don't understand then is if all of those issues are within the margin of appreciation for the state, why on earth would you be threatening court action? That's what I can't understand. If fatal fetal abnormality, rape, incest are all within, and Dr. Russell just said it, within the margin of appreciation of the state, we're the state, we decide, therefore why would you go to court?
But we're saying the margin of appreciation is broad, it's not unlimited. And so in other words, this
So
is
Dr.
not...
Russell was wrong then when he said that.
No, the margin of appreciation is with regard to where the line in the sand would be drawn, not
By the state.
by the state, not
Politicians.
not the access to the service.
I still don't understand why you'd be threatening then court action if it's within the margin of appreciation of the state. Yeah, that's what you've just stated. Those issues are within the margin of appreciation of the state.
No,
The
where
Assembly, the Executive, is the state. Why are you threatening court action?
at what point the provision in those circumstances is made unavailable is within the margin of appreciation of the state. Providing the service in those circumstances is not.
Expand on that point for me.
The CEDAW committee has been quite clear to the Northern Ireland Executive and the UK government that in circumstances of serious malformation of the fetus, rape and incest, there should be access to termination of pregnancy. How that then is regulated is within the margin of appreciation of the state.
I met Gary earlier this week, whose mother was violently raped, and he was conceived through that rape. Gary's married, has 3 children, one of whom was adopted. He has grandchildren. Does the Human Rights Commission believe that he has the right to life?
Of course, I mean, the issue in terms of, and again, the court's very clear, in terms of the choice of someone to give birth in those circumstances, a woman has a right in those circumstances to give birth, and nobody is suggesting in the
But
Human
Gary
Rights
didn't
Commission...
have a right to be protected under the law.
But at the
As
time...
an unborn child, the Human Rights Commission is clear. Gary doesn't have a right to be alive.
The right of an unborn child is inextricably linked to the right of the woman. That is our understanding of the legal position, and that's the basis on which we have commented on the amendment that's before you today.
Do you find it strange everyone who's in favour of abortion's alive?
I'm not sure that's... I'm not sure what I can say, Chair, to that question. I mean, it's not for the Commission to particularly get into the question of, other than in human rights, international law and standards, the question of a woman's right to choose and the rights of the unborn child is an issue that people have very strong views on. And the Commission's position is to look at the international human rights standards and offer advice on that. And if they feel it's been breached, to decide whether to take a legal action or not. And that's the basis on which we come to you today. I understand, given the views around the table, that's not, some of the things that I have said are not popular, to put it mildly, but that's the basis on which we offer advice to the committee.
It's not just that it's not popular, but the Human Rights Commission, even considering going to court on this issue, something that should be left for parliamentarians, undermines the democratic legitimacy of this Assembly if that was a course of action that the Commission would take. And that is a very serious consideration that the Commission should be putting to the forefront of their consideration before it would embark on that course of action.
I understand, and the eyes of the Commissioner are entirely open to the issue that you have made. Our role is to promote and protect international human rights standards. That's part of our mandate, and it's to offer advice, and that's what we will do. And I understand the point you're making, but that's the mandate of the Human Rights Commission, and it's a statutory mandate, and it's part of the wider checks and balances of which parliamentary democracy is a very important and cherished one.
Okay.
Absolutely right, but he's wrong.
Violent prevention orders.
I almost forgot that they...
So did I, till I was reminded. This shouldn't take that long. If you want to just outline.
Yeah, I'll ask my colleague, Dr. David Russell, to do that.
As members know, at the last appearance before the committee, we were asked to come back specifically on this provision with regards to its application to children. And we have gone away and we have considered it. And I have to say, as a starting point for the Commission with regard to the criminal sanction and what would flow from it, again, premising our position on the international standards, we have to draw to the Committee's attention that the United Nations Committee on the Rights of the Child has been clear that the age of criminal responsibility in all contracting states should be a minimum age of 12, and that ideally the age ought to be raised to 14. Therefore, on the basis of this, the provision of VOPO to a child causes an initial problem because of where the age of criminal responsibility sits at present within Northern Ireland. And the Commission would advise the Committee that it considers, whilst considering the application of this particular provision, that in order for it potentially to operate compatibly, that the first point of principle should be that the Committee should consider the age of criminal responsibility in Northern Ireland within the content of the bill, so that anything within the justice system thereafter is compatible with the binding human rights standards. And as I said, it's the minimum age of 12, as opposed to as it stands at the minute in Northern Ireland, which is the age of 10. If that wasn't the case, as a first instance then with regards to a violent offender prevention order, it's the Commission's considered view that as it stood, if it applied to a child, it would be in breach of the UNCRC Article 43. So that's our basic position. In addition to that, I'd also draw the attention that in terms of a qualifying offender under Section 53(3) of the bill, it enables an application to be made with regards to an offence that has taken place outside of the jurisdiction. Exactly the same principle would have to be applied with regard to the application of the provision in order for it to be compatible with the Convention on the Rights of the Child, i.e. if a child had been convicted in a state where the age of criminal responsibility was below the age of 12 for the base offence, and then on the basis of that an application was made for a VOPO, well then that too would engage the CRC. The fact that the initial offence was committed outside of Northern Ireland does not obligate the responsibility of the Assembly in terms of ensuring human rights compliance for the child in question. Finally, if a decision was made to continue with the provision, and assuming that these issues were addressed in order to ensure compliance with the binding treaty obligation, we'd also remind the Committee that the CRC is clear, even with regards to juvenile justice, that the best interests of the child, in this instance a child offender, has to be a primary consideration, in addition to the consideration of the potential harm to others. Happy to take questions.
Okay, thank you. In terms of those concerns about compliance, obviously this is a bill that has already been introduced into the Assembly. So where was the Commission in terms of the advice that it should have been giving then to the Department? because it's now started its journey, obviously. So if the Commission is there at the start of the process, surely this is something that should have been detected, alerted and considered at that point.
Well, I think that in part is fair comment. The only question I would say is that in terms of our initial analysis, we had looked at this in terms of a provision for adults rather than for children, and we had there were no legal issues that we were raising in terms of adults. And I think it's probably a reasonable criticism to say, well, should we have envisaged this being an issue for children as well? I don't think we sat down and thought about this. Our kind of assumption was that the VOPOs were a provision that was for adults rather than for children. It was only frankly, and as I understand, when the Children's Law Centre raised the issue, that it came to our attention. So, in as much as in an ideal world we should have looked at this earlier, I can only apologise. But that's the basis on which, clearly we're not suggesting that violent offender, that VOPOs don't apply to adults. That's the issue that we had addressed initially. We hadn't really thought about the issue of how it applies to children and young people.
The other thing I would say is, just to be clear, I mean, there's no grounds in terms of human rights laws as to why one could not apply to a child. The question is, if it were to apply, it would have to be apply in a compliant fashion.
Yeah. Mr. McGlone?
Yep, Chair, just to clarify your point there, as I was read it last night, in the event of an application for a VOPO with regard to the defined child, the best interest of that child would be a primary consideration in addition to the consideration of potential harm to others. You just explain that to me, because if you have potentially a very, very violent person, how would the primary consideration be the child?
It's a primary consideration, not the primary consideration.
A primary, but can you explain that to me?
Well,
it says there, in addition to the consideration of potential harm to others. I think I might, if I was the person who was potentially at risk, I would be hoping that instead of being an add-on, I would be a primary concern too.
Well, that's the language of the treaty. So the CRC, because of the nature of children, the rights provisions that are afforded to children are very different from adults.
Yes.
And they're particularly different with regards to how children should be treated whenever they engage the criminal justice system. Like I say, it says a primary consideration. It doesn't say the only consideration, and there's a balance at play here. And actually, in the scenario that you are suggesting, if you could think of a potential violent offence to be produced by a child, a primary consideration might, depending on the circumstances, be to apply a VOPO, because that's in the child's best interest, because it's preventing them from committing a criminal offence. So I don't think there's a definite, just because it's a primary concern doesn't mean that the outcome is necessarily set in stone.
And this would be applicable 12 to 18. That's the age range.
It would be applicable in Northern Ireland from the age of 10.
Sorry, I know, but I was reading, I understand that. From 10 to 18.
To 18.
Yes. Aye.
And then beyond for adults.
It's just that I've seen some 16, 17, 18-year-olds and they could do a fair wee bit of damage, you know.
Well, just to be clear, that's why I said the international standard is that the age of criminal responsibility should be set at a minimum of 12, and even under the ideal circumstances, 14. So the 16-year-old, there's no concern particularly other than with regards to the fact that that would still be a child and their engagement in the criminal justice system should be different.
I do appreciate this would be in very rare and exceptional circumstances, but okay. And you reckon that the bill should be amended then to incorporate?
I raised the issue of the first point of principle, which is the introduction of a VOPO, because it's part of the criminal justice system, raises an initial concern with the fact that anything within the criminal justice system in Northern Ireland at the present that would apply to a child above the age of criminal responsibility is in violation of the UNCRC.
Right.
If the age of criminal responsibility was raised to 12, then we would be having a different discussion.
Okay, right. Thanks very much for clarifying that. Thanks, Chair.
anyone else on this point? Can I thank you very much? I appreciate that. It was quite a lengthy and lively session, and I certainly appreciate you taking the time to indulge us during that. So thank you very much.
Thank you, Chair. I've probably had more enjoyable afternoons, but I think it's probably important that all of this is aired, and so thank you.
Yeah, thank you.
Thanks. I had to say touche.
Okay, members, we'll move on to the next evidence session. And if representatives are able to join us. Pages 37 to 50 of the meeting folder has all of the relevant pages. Okay, can I welcome Liam Gibson, Northern Ireland Development Officer for the Society of the Protection of the Unborn Child, Bernadette Smith, Precious Life, and Katrina Ford, Women's Network, to the meeting. As with previous evidence sessions, we'll record this by Hansard and then it will be published in due course. So I'm not sure who I'm handing over to at this stage for opening remarks in terms of your submissions.
Ladies first.
If you want to take us through just briefly the submissions, then members can then ask questions after that.
Okay. Go ahead,
Katrina.
I'm speaking on behalf of Women's Network, which is a pregnancy counselling service that fully informs women of the procedures and risks of abortion and provides women with compassionate alternatives to abortion. Whatever a woman needs to overcome her fear and panic when faced with an unplanned pregnancy, Women's Network is always there to provide loving care and support during pregnancy and after birth. Soon to come in the new year will be a new pregnancy care facility in Northern Ireland called Stanton Healthcare. This will take over and expand the services of Women's Network, and such services will include pregnancy tests, ultrasound scans, pregnancy, childbirth and parenting education, maternity and baby supplies, and counselling on abortion, adoption and post-abortion stress. Stanton will work alongside local GPs to provide referrals for medical attention and treatment as required, and will also work alongside other supportive organisations to provide referrals for adoption, housing and social services. If a woman enters the Mary Stopes Centre or any private abortion centre for help, it will cost her money and her baby. The doors of Stanton Healthcare will always be open, and anything a woman needs to help her through her pregnancy will always be free. Women and their babies deserve better than abortion, and Stanton Healthcare seeks to protect them both from the exploitation of Mary Stopes and other profit-driven abortion providers. That is why Women's Network supports Mr Jim Wells' proposed amendment to the Criminal Justice Bill, which proposes that no defence to the criminal charge of abortion would be available to anyone who performed an abortion for a fee at a private medical centre. 3 months ago, Women's Network was contacted by a young pregnant woman who was very distraught after being told that her baby appeared to have a disability. When 20 weeks pregnant, her consultant suggested that her baby was incompatible with life, and it was recommended that she go to Mary Stopes and have an abortion. Women's Network contacted Mr Edwin Poots for assistance in this distressing case, and thanks to their involvement, this young woman and her newborn baby, Poppy Grace, were provided with perinatal care and comfort care in the Northern Ireland Children's Hospice. Poppy Grace was diagnosed with a very rare condition called No-Lixova syndrome and lived for 8 precious days. Surrounded by the loving warmth and care of her mother and family, she sadly passed away in the Northern Ireland Children's Hospice on Wednesday, the 1st of October. Parents, when faced with a devastating diagnosis, deserve better than cold and callous dismissal and abandonment. Mary Stopes proudly professes to be the UK's leading provider of sexual and reproductive healthcare services. In an editorial published in the British Medical Journal in May 2014, Anne Faraday, the Chief Executive Officer of the British Pregnancy Advisory Service, declared that women in Northern Ireland need access to abortion for the same reasons as women in the rest of the UK. In her book, Unplanned Pregnancy, Your Choices, Ms. Faraday writes that unplanned pregnancy is one of the most common medical problems faced by sexually active women, and many tens of thousands of unplanned pregnancies end in abortion, making it the most common operation among women. However, abortion should not be understood as a health service in treating a physical or mental health condition. It is in fact no more than the intentional killing of the most defenceless and vulnerable human being, the unborn child. Don't worry, I'm nearly finished. So,
Okay.
abortion also harms the woman. For instance, despite Mary Stopes stating that there has been no proven link between abortion and breast cancer, researchers in 2013, after examining 36 studies that investigated the association between abortion and breast cancer, concluded that the risk of developing breast cancer among women having one abortion increased by 44%, and that the risk of breast cancer increased as the number of abortions increased. Research was conducted over a 30-year period, examining the extent to which induced abortion, live birth and pregnancy loss were associated with increased or decreased risks of mental health problems, including depression, anxiety, suicidal ideation, alcohol and drug dependence. In 2009, it revealed that exposure to induced abortion was consistently associated with increased rates of mental disorders. This study showed that although abortion was associated with increased mental health problems, no increase was evident for those having unplanned pregnancies that came to term. This evidence clearly poses a challenge to the use of psychiatric reasons to justify abortion for women having unplanned pregnancies. According to a 2013 research paper by Baron Calhoun, John Thorpe and Patrick Carroll, Northern Ireland and the Republic of Ireland continue to be the safest places for pregnant women and their babies. Over the 40 years of legalised abortion in Britain, there has been a consistent pattern in which higher abortion rates have run parallel to higher incidence of stillbirths, premature births, low birth weight neonates, cerebral palsy and maternal deaths as consequences of abortion. In contrast, both Irish jurisdictions consistently display lower rates of all morbidities and mortality associated with legalised abortion. But if unplanned pregnancy is one of the most common medical problems and abortion is the most common operation, supposedly providing the cure, why does Britain continue to lag behind Northern Ireland and the Republic of Ireland standards of maternal health? Perhaps Ms Faraday and her fellow profit-driven abortion providers should reconsider hiding behind the rhetoric of a woman's right to choose. It does not serve women's needs or best interests, but only fools them into believing that they need the likes of BPAS or Mary Stopes to kill their unborn children. And to conclude, on behalf of Women's Network, I would like to reiterate that rather than erasing the problem of an unplanned pregnancy with the immediate solution offered by a morning's visit to an abortion centre, every pregnant woman deserves to be comforted and assured that she is not alone to cope with her pregnancy and the birth of her child. Abortion is never the solution to an unplanned pregnancy, and Mary Stopes or any private abortion centre will never be wanted or needed in Northern Ireland. Thank you.
Thank you very much, Katrina. Is there any other opening comments from Bernie? In terms of your submission?
I was just going to present the submission. No?
Yes.
Yeah, I'm
feel
happy to
free.
do that. Okay. Okay, I'm here on behalf of Precious Life, the leading pro-life group in Northern Ireland, in response to the Justice Committee's invitation to give evidence on the Criminal Justice Bill and the proposed amendments. Since 1997, Precious Life have worked tirelessly to protect Northern Ireland's unborn. And through activism throughout Northern Ireland, lobby campaigns, and through the courts and our information drives on the street, we have helped to save many babies and mothers from the horror of abortion. In regard to Mr Jim Wells MLA's proposed amendment to the Criminal Justice Bill, I wish to state from the outset, that Precious Life and the vast majority of people in Northern Ireland would support this proposed amendment to the Criminal Justice Bill. In fact, I think there was nearly 35,000 submissions presented through a Project Justice during the consultation period. Abortion in Northern Ireland is a criminal offence, and it's governed by Section 58 and 59 of the Offences Against the Persons Act and Section 25 of the Criminal Justice Act, Northern Ireland 1945. There is a defence which may be raised that the abortion was performed to save the life of the pregnant mother or to prevent a real and serious adverse effect on her physical or mental health. This defence is not automatic and depends on the circumstances of the act carried out. The sole purpose of the law, the sole purpose of the above legislative provisions is the protection of the unborn child. Mr Wells' proposed amendment makes clear that a defence to the criminal charge of abortion would not be available to anyone who performed an abortion for a fee at a private medical centre. The purpose of this amendment is to ensure that private medical centres such as Marie Stopes Centre, which opened its doors in Belfast in October 2012, cannot legally carry out abortions in Northern Ireland. Private facilities' sole purpose is to destroy unborn children, and its sole interest is profit. And I'd like to refer to a whistleblower who drew attention to what was happening within Marie Stopes. And she said, everything is geared to getting as many people in there for terminations as possible. She alleged, when I started in July 2004, the branch was performing between 20 and 30 abortions a day. But we were told that Essex was doing 50 a day and that we were underperforming. So they called a meeting last November at which we were told our bonuses were being withheld until we caught up. We had 2 wards upstairs and it was like a car production plant. When I started, people would be given a few hours to recover, but by the end they were waking them up within half an hour and getting them out. Mrs Jargua also claimed the bonuses acted as a sales incentive, the way they might if you were working on a perfume counter or a department store. The more people you got booked in for terminations, the better bonuses you would get. Marie Stopes' professed mission is children by choice, not by chance. However, the law in Northern Ireland ensures that every unborn child, that every human being, born and unborn, has the right to life, a right not to be intentionally killed. Precious Life wants unborn children and their mothers protected from abortion, and is therefore totally opposed to the Marie Stopes Centre or any private abortion facility in Northern Ireland. Precious Life wholeheartedly supports Mr Wells' proposed amendment to the Criminal Justice Bill and its prohibition of commercial provision of abortion services in Northern Ireland. And I'd like to address to the Justice Committee a number of concerns regarding Marie Stopes or any private abortion facility in Northern Ireland. Marie Stopes or any other private abortion facility is not needed in Northern Ireland. It has been widely reported that both Northern Ireland and the Republic of Ireland are among the safest places for women to give birth. Over the 40 years of legalised abortion in Britain, there has been a consistent pattern in which higher abortion rates have run parallel to higher incidence of stillborn, premature birth, low birth weight neonates, cerebral palsy and maternal death. And this is the consequences of abortion. In contrast, and Katrina referred to it, the paper from Dr Brian Colquhoun, where we can see that Northern Ireland and the Republic of Ireland have displayed lower rates of mortality and morbidities associated with legalised abortion. So the law in Northern Ireland ensures pregnant women receive world-class medical care, both because mother and child are treated as patients. And in difficult cases where the mother's life is in danger, she and her unborn child receive the best obstetric care, as has always been the case here. Mary Stopes proudly professes to be the UK's leading provider of sexual and reproductive health care services. However, abortion should not be understood as a health service, a treatment for a physical or mental condition, as it's in fact the deliberate killing of an unborn child. And it must be understood there is no medical condition when the life of a pregnant woman can only be saved by abortion. Operations, treatments and medications that have their direct purpose and the cure of a proportionately serious pathological condition of a pregnant woman are legally permissible when they cannot be safely postponed until the unborn child is viable, even if they were the result of the death of the unborn child. If through careful treatments of the pregnant woman's pathological condition, the unborn child inadvertently dies or is injured, this is a tragic, but if not unintentional, is not unethical and not a criminal offence. For example, if a pregnant woman develops cancer in her uterus and the doctor recommends surgery to remove the cancerous uterus, as is the only way to prevent the spread of the cancer, removing the uterus will always lead to the death of the unborn child, who cannot survive at this point outside the uterus. In this scenario, the surgery directly addresses the health problem of the woman. The organ that is malfunctioning, the cancerous uterus, the woman's health benefits directly from the surgery because of the removal. And it's been very clear time and time again that there's evidence that shows that there's no medical necessity. In fact, Professor Eamon O'Dwyer, Professor University College in Galway, said there's no circumstances where the life of the mother may only be saved through the deliberate and intentional destruction of her unborn child. So in order to determine the appropriate treatment of suicide in pregnant women, one must turn to the evidence that's already available from consultant psychiatrists with extensive experience in caring for patients with suicide and pregnant women with mental health problems. When suicide intent arises in pregnancy, it is in the context of mental illness. A suicide risk assessment must be carried out when a pregnant woman threatens suicide, and this will determine the appropriate care plan. Appropriate treatment involves psychological intervention, nursing, social support and perhaps medication as indicated by the needs outlined in the case history and the examination of the patient. According to Patricia Casey, a Professor of Psychiatry in the University College Dublin, in her submission to the Oireachtas Committee on Health and Children in May 2013, there is no evidence that abortion is a treatment for suicidal intent. In fact, to offer an abortion to a distressed woman who is psychologically ill is seriously ill-advised, since the woman's capacity to make such a life-changing decision is frequently impaired. Moreover, an increased risk of relapse, both immediately and the long-term post-abortion. It's important to stress that preserving the pregnant woman's safety is done by care, support and psychological help, not by the killing of her unborn child. As I've just stated, in difficult cases where the mother's life is in danger, she and her unborn child receive the best obstetric care, as always been the case in Northern Ireland. Mary Stopes or any other private abortion facility is not offering or providing any treatment that cannot be ethically and legally provided in the NHS free of charge. Pregnant women in Northern Ireland do not need Mary Stopes or any other private abortion facility to receive necessary treatment and care. And as former Health Minister Mr Edmund Pruitt stated, there is no cases of women dying in Northern Ireland. In a meeting with the Justice Committee on the 10th of January, representatives from Mary Stopes 2013, Mary Stopes Centre in Belfast failed to provide a detailed explanation of how pregnant women are medically assessed in order to determine whether an abortion can be performed to save the life of a pregnant woman or to prevent a real or serious adverse effect on her physical or mental health. The representatives failed to defend how Mary Stopes healthcare professionals could hold an honest belief and have reasonable grounds to believe that abortion was necessary to save a pregnant woman's life or to prevent injury to her physical or mental health. Alarmingly, Don Purvis, the Programme Director of Mary Stopes Centre in Belfast, when questioned by the Chairperson of the Justice Committee, admitted that there is nothing to stop the Mary Stopes Centre in Belfast from carrying out abortions right up to birth. So there appears to be no accountability for services provided by the Mary Stopes. May I add, Mary Stopes is a member of Voice for Choice. Voice for Choice is a UK coalition of pro-abortion organisations who are working to change the change the law on abortion in the UK to pressurise doctors who are pro-life by forcing them to refer them to other doctors, and they want to extend this Amended Act to Northern Ireland. Sorry. Yep, and also to draw attention to the fact that there appears to be no accountability for services provided. Although it has been registered with the Regulations and Quality Improvement Authority, RQIA, it's been very clearly outlined in their evidence that the RQIA would have no role in ensuring that abortions were not carried out within the legal framework. Our concern with Marie Stopes will not be providing. Precious Life's concern that Marie Stopes will not be providing pregnant women with medical treatment and care that needs to be amplified by the Marie Stopes Association, with reported deaths of numerous women, and we could go on and on. I think Liam will probably be covering some of the effects of the recent deaths. In 27, for example, a 15-year-old girl died after an abortion at the Marie Stopes Clinic. A woman from the Republic of Ireland also died in a taxi after an abortion. She suffered a heart attack and it was caused by extensive blood loss. We could go on and on. But also to refer to the fact that it's also been reported that Marie Stopes has performed illegal abortions all over the world, and I think that evidence was presented by was debated here in 2013 as well, where we have evidence that they have been involved in illegal abortions in Sudan, Zambia and Kenya. And in 2007, the video was exposed where Marie Stopes, International Programme Director, admitted at an abortion conference in London that Marie Stopes do illegal abortions all over the world. In a nutshell, Marie Stopes break the law in order to change the law. There must be accountability, transparency and an open working relationship between healthcare providers and the Department of Health and Social Services and Public Safety. So clearly that hasn't been the case from the history of Marie Stopes. Without the safeguards, pregnant women in Northern Ireland are vulnerable and open to exploitation and exposed to physical, emotional, psychological harm. Precious Life urges the Justice Committee to adopt Mr Wells' proposed amendment to the Criminal Justice Bill and ensure that the Marie Stopes Centre in Belfast or any other private abortion facility does not perform abortions in Northern Ireland. Pregnant women in Northern Ireland do not need Marie Stopes or any private abortion facility to receive necessary treatment and care, considering that abortion is the deliberate killing of an unborn child, a cold and costly, direct and wrong social solution to the troubles faced by a vulnerable pregnant woman. One can appreciate why Britain falls below Northern Ireland and the Republic of Ireland's standards of maternal health. Marie Stopes' rhetoric of children by choice, not by chance, does not serve women's needs or best interests, but only dupes them into believing that the choice to pay for higher skilled hands to eradicate the existence of their unborn child is what they deserve. We say women deserve better. With loving care and support and appropriate medical treatment, every pregnant woman should be comforted and assured that she is not alone to cope in pregnancy and with the birth of her child. Abortion is never the solution to an unplanned pregnancy. Marie Stopes or any private abortion facility will never be wanted in Northern Ireland. And I'm sorry I'm going on a bit, but there's just one last... I received an email from a worker from Marie Stopes in Kenya. I worked in Marie Stopes in Kenya for 2 years as a clinician and a service provider. Marie Stopes has 24 branches currently in Kenya, which I now call killing centres. Abortions have been done there daily for the past 20 years. Even though this is unlawful, there is no law in Kenya that allows them to do that, but they are still being protected by a corrupt pro-abortion politicians and government. There have been many deaths of women procuring abortions at these centres, while the majority of women have had countless perforations and other complications that arise from the procedures. On the 21st of January, I joined Marie Stopes. I reported for work on the 23rd of January, and after 14 days of induction, I was posted at a centre. While there, I witnessed a lot of horrors and was doing abortions as big as 20 weeks and fully formed babies. They were so difficult to watch and comprehend. Since that time, I've never recovered. The most shocking was a 27-year-old pregnant woman, 28 weeks pregnant. The baby died after crying for 6 hours. There was nothing I could do to help. In 3 months, I hit 100 abortions. At no time did the police ever come for us, approach us, or any anti-abortion crusaders. This was a worrying trend, but I continued. I moved on to a different clinic And by the time I started working in this new clinic, I was already badly affected. I was having bad dreams about babies crying all around me, and I believe as a result of aborting the 20-week pregnancy, even during the day, I sometimes heard babies crying. It was so worrying. This became difficult and psychologically affected my work. Even performing my duties was becoming an issue. I stopped during abortion for over 16 weeks gestation. This reflected negative on our clinic income. I wanted to save myself from this mess, and I succeeded in saving a few lives, but then the numbers dropped and the income dropped. The bosses came to the clinic one day and asked me why the clinic was not performing well. I said that I could not continue doing such late-term abortions. The best way for them to get rid of me was to label me with stealing money, blah, blah, blah. They have done this to a number of other Marie Stopes employees and also feared of coming out because of threats. I am writing this in fear. Because they did this, I decided I could not continue with the killings anymore. And there's a clear message from someone who works in Marie Stopes. They are there to kill your next generation. Killing is not a solution for women to live a comfortable life. In Kenya, Marie Stopes are breaking the law. The law in Kenya says that abortion is illegal in Kenya unless it's the only way to save the life of the mother, when it's absolutely impossible, and the only way to save life of the mother is terminating the pregnancy. I have never, in my time working with Marie Stopes, ever came across one case like that. They are there to make money because they charge a lot. They charge a massive amount for abortions to be done. For psychological disturbance, as for my case, it's difficult for me to live peacefully. This has affected my social and psychological well-being. There is needs for more efforts for sexual behaviour. And I just received this email yesterday, and this guy asked me to read it out here today to highlight that Marie Stopes is not needed in Northern Ireland. He's been following the case and he has asked me to refer to it, so thank you for listening.
Liam?
Thanks very much. Thanks for the invitation. Just to begin with, just say a little bit about the Society for Protection of Unborn Children. We were founded in 1967 in order to oppose the passage of the Medical Termination of Pregnancy Bill, which later became the Abortion Act. One of our founder members was Dr. Alec Bourne, who himself was an abortionist and an activist to bring about reform of abortion laws in the United Kingdom. In 1939 he was prosecuted but acquitted after having performed an abortion on a 14-year-old girl who had become pregnant as a result of being raped by a group of soldiers. By 1967 he had had a change of heart and realised that this had in fact opened the floodgates, and did everything within his power to prevent the passage of the 67 Act. Unfortunately, he was unsuccessful. But since then, the Society for Protection of Unborn Children have been very active, both in research, education and lobbying, and also in the courts. We've had a number of cases, both domestically within England, Scotland and Wales, and in Northern Ireland. In 2009 and 2010, we launched 2 successful applications for judicial review of the medical guidance from the DHSSPS, which resulted in it being withdrawn. At the present, we're supporting 2 Glasgow midwives who are before the Supreme Court in London. Their case was heard just last month, and we expect the judgment to be handed down in the near future. It'll be a very, very important case for for medical professionals who want to protect their right of conscientious objection and non-involvement in abortion. We have accreditation at the UN and lobby both at Geneva and in New York. One of the principal messages I'd like to get across this afternoon is to refute some of the criticisms of the present law in Northern Ireland that I think have already come up in some of the previous evidence sessions. In particular, the criticism that the Offences Against the Person Act is simply a Victorian piece of legislation and is outdated. It is true that it was passed in 1861, but having said that, the principles that are embodied in that law are actually much, much older than the Victorian era, and in fact date back to the 5th century before Christ and the foundation of Western medical ethics and the Hippocratic Oath. Now, having said that our law is principally the same as that espoused by the Hippocratic Oath in the 5th century BC, those principles that argue against medical personnel ever taking a human life, even within the womb, were re-espoused in 1948 by the World Medical Association and the Declaration of Geneva. The doctors, this arose, of course, after the medical case at Nuremberg, when Nazi medicine had gone into the fields of euthanasia and abortion. Now, the euthanasia program within Germany was very well known. It's less well known that one of the first acts that German occupation put forward in Poland was the decriminalisation of abortion law. The doctor's oath bound doctors to maintain the utmost respect for human life from the time of conception, even under threat. Now, and asked doctors to never to use their knowledge, medical knowledge, against contrary to the laws of humanity. Now, in that reference, contrary to the laws of humanity, that is a direct reference to the Universal Declaration of Human Rights. This declaration was made within 3 months of the adoption of the Universal Declaration of Human Rights. The Universal Declaration of Human Rights, as I hope you're aware, provides for human rights for all members of the human family, regardless of any distinction whatsoever, whether that's race, colour, political opinion, birth, or any other status. So whatever way you want to cut it, you know, the human rights apply to all members of the human family, regardless of their stage of development, and also regardless of the circumstances of their conception. At Nuremberg, two of the people who stood trial because of their involvement in the decriminalisation of abortion in Poland were Richard Hildebrandt and Otto Hoffmann. They weren't abortionists themselves. They were actually just party functionaries who implemented the law. Now, it's very ironic that people who stood trial in Nuremberg for the decriminalisation of abortion in Poland, there were people who actually stood trial there for doing what Amnesty International now argue that the Northern Ireland Assembly ought to do. Now, there is actually, contrary to what has been stated previously here, international human rights treaties and legislation recognise the right to life, the unconditional right to life. Not one international instrument of human rights recognises the right to abortion. Not one. Now, actually, the American Convention on Human Rights explicitly states that the right to life applies from conception. The European Convention on Human Rights doesn't state that explicitly, but having said that, it refers to the Universal Declaration of Human Rights, which, as I've already outlined, excludes any section of humanity from being having its rights abrogated. Now, the European Court of Human Rights has shown a great deal of latitude in its interpretation of the right to life whenever it comes to abortion cases. For a court that actually covers 50 member states, it's not that where there's no consensus on the issue of abortion. It's not surprising that they give a wide margin of appreciation to member states to decide what their own abortion laws are going to be. There's no question that the law in Northern Ireland would be in breach of the European Convention on Human Rights. Whenever the United Kingdom of Great Britain and Northern Ireland actually helped to draft the European Convention on Human Rights, the whole of the UK had the same law as we have now. So the idea that somehow it was in breach all of those years, and we are in breach now of the convention that the UK actually helped to draft, is simply preposterous. In 2005, in the case of Vaux versus France, the court said that the embryo/fetus belongs to the human race. Now, the court didn't go any further for the reasons that I mentioned, that it does give a broad margin of appreciation. But I think anybody who's interested in human rights would recognise that if you're a member of the human race, if you belong to the human race, then you're automatically granted all the human rights that we share equally. So there is absolutely no obstacle in international law, either the law that's actually applicable to the courts in the UK, i.e. the European Convention, or the wider international instruments that don't actually have any legal standing in our courts, such as the International Convention on Political and Civil Rights. None of those things would prevent the law from Northern Ireland staying the same, or actually adopting the amendment that is being proposed. Also, the case of Tysiąc versus Poland from 2007, that is somehow being presented as recognising a right to abortion. That didn't happen. It was the court was very specific that where abortion is already lawful, then there can't be obstacles that are outside that law from preventing people from exercising a legal right that they have. Since this amendment wouldn't actually prevent application of a right that already exists, which would be to basically the right to access healthcare that's going to prevent a death or long-term permanent damage, then there shouldn't be an issue with that at all. Furthermore, any case that would go from Northern Ireland would have to exhaust all domestic remedies first. Interestingly, the Society for Protection of Unborn Children had an amicus brief in both 2005 with the D versus Ireland case and the ABC versus Ireland case in 2010. While the court rejected the application from D in 2005 because it failed to exhaust all domestic remedies, somehow that wasn't applied, that standard wasn't applied to the more recent case, and arguably that case of ABC versus Ireland should not have been even heard, because this is actually set a precedent of the court going against the terms of the convention itself. Furthermore, in Article 53 of the convention, it actually allows countries to have a higher standard of human rights than apply within the convention. So that was to prevent the convention being used to actually lower human rights standards. And very clearly, we have a higher standard of recognition of the right to life of the child in the womb than many countries across Europe. The convention cannot be used to make our standards lower. We certainly do have a recognition of the right of the child within the womb, and even the recent case of I think it's Siobhan Desmond versus the chief coroner, the senior coroner in 2003 recognised that a child from the point of viability can be recognised as a person under the law and can therefore be entitled to an inquest. Now, in winding things up, I just want to say that very much the talk about human rights standards actually are very well chosen words. The human rights standards, these are basically the recommendations of the CEDAW committee, the Convention on the Elimination of Discrimination Against Women. Now, the CEDAW committee has no judicial standing whatsoever. Abortion is not even mentioned in the convention itself. The committee was set up a while after the convention was ratified, and there is simply, their opinion is just this opinion of an NGO. It has no legal standing and cannot dictate to countries what their criminal law ought to be. The Convention on the Rights of the Child, which both the UK and Ireland are signatories, does recognise the right to life before birth. It's in the preamble. It says, bearing in mind that as indicated in the Declaration of the Rights of the Child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. Now, the Article 1 acknowledges that a child is anyone under the age of 18. It doesn't give a starting date. It doesn't say from birth. It says anyone under the age of 18. Article 2 again specifies the right to life, regardless of origin, property, disability, birth, or any other status. Article 6 recognises the right to life, and Article 24 recognises the duty of states to ensure the highest level of maternal health care during pregnancy. Now, this is as a right of the child, it's not the right, the mother is not the rights holder in this document, it's the child, and that recognises the need for appropriate prenatal and postnatal care for the child. Finally, the idea that restrictive abortion regimes drive people to illegal abortions is simply unfounded. Within the first 20 years of the implementation of the 1967 Abortion Act, the police in England and Wales recorded 986 offences of procuring illegal abortions and brought 293 prosecutions. I have further material dealing with the deaths due to legal abortions and illegal abortions in Britain, but I think I can make those available to anybody who wants them. Thank you.
Thank you very much. Members will have some questions now. Mr. McGlone.
Yep, thanks very much, and thanks very much for your submission. Just specifically yourself there, Liam, you made reference to, and obviously I'm coming from this from a pro-life perspective itself, right? But you made reference there was no question that law in Northern Ireland would be in breach of European Convention, and you referred to no obstacle in international law around this in support of your case. And you said you then quoted various articles around the rights of the child. Now, two things: do you have you as an organisation taken legal advice around those? And the second thing, have those rights been asserted or interpreted as standards in either more regional law or international law? It's just we've been hit over this last while at compliant with this international standard. It's compliant with that international standard as the case for liberalisation of abortion laws, as it turned out in the north here. So can you provide us with, if you like, the counter legal interpretations of what the law is or what these standards are that are being upheld? I don't expect you to have them with you today unless you're a very well-renowned, as you are, but a very well-renowned legal expert in international law. But I think those would be very helpful to us, Chair, if that could be provided.
Certainly, I'll do what I can to make sure that I get those to you. I can give you a briefing on EU law, which is binding, unlike
yes.
General international law on human rights. EU law is binding, and we took advice on that specifically to do with this this amendment and the possibility that it would fall foul of basically the transportation of services.
Right.
Our advice came from a
a lawyer who does work for the British government and was verified by an Austrian colleague. And I can make that available to you.
I was going to ask you if you could share that with us. That would be very helpful, Chair.
There's absolutely no, the EU have absolutely no interest in controlling criminal law in the member states. And this is what we're talking about. This is an amendment to the Justice Bill, and it just doesn't come under the remit of the EU. Now, the more general standards that you're talking about, those are basically fraught with controversy. The Universal Declaration of Human Rights is quite clear. However, many of the treaty bodies that are supposed to oversee compliance, even though they don't have any legal standing, they're very influential within the United Nations, and that's why we find that in order to keep delegates informed of the sort of language that's arising in various conventions, there is a trend towards basically saying black is white and turning the original purposes of the UN and the Universal Declaration on its head. Really, there is a need to go back to the starting point. Like all human institutions, the UN and the European Court are subject to natural decay, and unfortunately, we're finding that they're not prepared to stand over. They prefer to reflect human rights standards rather than actually uphold the original standards that were agreed.
Thanks very much, Chair.
Okay, so one of the commentaries we had earlier from the Human Rights Commission was that there is no separate recognised human rights for the unborn child in any international human rights laws, that there are rights but they are interlinked with the rights of the mother. They're not a standalone, separate, recognised form of rights for the unborn child. There are rights, but they're interlinked, inextricably linked to the rights of the mother. What would you say in terms of that?
The European Convention, the European Court has always taken the point of view where it's done a balancing exercise of weighing the rights of the child against the rights of the mother. That's understandable if you want to maintain maintain a status quo where there's no consensus. In the Titian's case, which I mentioned earlier, involved a mother who had a threat to her eyesight. It's possible that during the process of giving birth, she might have her eyesight might have been damaged by the strain. She had an application under Polish law which allows abortions in cases of serious threat to the health of the mother. She was denied an abortion simply because she could have had a cesarean section, or wasn't even a specialist disagreed whether the level of threat was really as grave as that. Whenever the court heard that case, it's decided that that her way was obstructed because there was no procedure for an appeal beyond the ordinary medical opinion and second opinion. One of the dissenting judges at that case, Spanish judge Jorge Borrego, I think his first name is. He said that he found that it frightening what the court had done, because basically it had said that there was a 6-year-old boy alive in Poland whose birth was actually a violation of the European Convention on Human Rights. Now, as for a specific and separate article that recognises the right to be born for unborn children. It's not separate. It is encompassed because the the Universal Declaration of Human Rights was drafted in order to encompass everyone. So it's not separating out any particular class, any person due to the stage of their development or their age or any other status. Now, the term "any other status" covers everything that's left unsaid in the Universal Declaration. So yes, I would agree that there's no separate instrument that recognises the right to life of the unborn child in exclusion to the human right to life. I'd have to agree that that's the case, but that's, the drafters of the Universal Declaration of Human Rights specifically did not want to separate out particular groups. They wanted something that was all-encompassing. The Convention on the Rights of the Child, I think, is very clear in what I've pointed out to you. Again, the American Convention on Human Rights does specifically recognise the right to life from the moment of conception. So without knowing precisely what was said, I would agree and yet say that, no, that's not a problem. The right to life is recognised in all the major international conventions.
CEDAW was cited as well. You've touched on it briefly. You're saying quite clearly that CEDAW has no jurisdiction.
Yes, well, it's not incorporated in the UK law, so therefore, it can serve as an aspiration, but no one could seek redress of their grievance under the CEDAW Convention. It's most of the CEDAW Convention, and it doesn't actually mention abortion at any point in the actual text of the convention, but most of the instruments are the articles that are covered by the CEDAW Convention can be covered in a country like the UK anyway. It's not really the idea of discriminating against women is unlawful already. So it's not really a problem. The say that because abortion is unlawful and that's discrimination against women, well, that has a number of cases have actually tried to get that into the European, the court to back them up on that, and it's never ever worked.
Okay, Mr. McCartney.
Thank you very much, and thank you for your presentation. Just a couple of sort of brief points, and I realise these are separate, but I mean obviously our presentation's very much the same. But in your document, Liam, you're it's very, very explicit, where it says we are opposed to abortion, whether performed within the health service or the private sector. Mm-hmm. Is that would that be something shared by all three?
Yeah, well, because the evidence shows very clearly that there's no medical necessity. We're not opposed to medical treatment, and I clearly outlined that in my presentation, where it's sometimes in pregnancy there can be life-threatening conditions that are presented, like for example, a mother may have a cancerous uterus. Sometimes a mother could be diagnosed with breast cancer, preeclampsia. There are conditions. But in 2014, it's very, very rare, and I mean that evidence was presented during the whole debate in the Irish Republic, that there's no medical necessity. No woman will be denied medical treatment to save her life, but at the same time treating her unborn child as a second patient. On some very rare occasions, like for example the cancerous uterus, where in the removal of that uterus, the child may die as a secondary effect, that the intention was not to take the life of the unborn child. But I'm sure I speak for the three of us here. We would want to make sure that all women are given the medical treatment, and that is the case here in Northern Ireland. I've worked with women for 17 years through crisis pregnancy support, dealing with different cases where I've had to refer them for second opinions. And in all those cases, there's always been a life-affirming, there's always been medical care there for that woman. For example, in preeclampsia, every mother who presents with preeclampsia will always be given the appropriate drugs, bed rest, whatever that may be, to protect her health. And the majority of doctors who are treating 2 patients will take that pregnancy as far beyond viability as possible to safeguard the life of the mother and the child. Sometimes the baby may have to be born prematurely. That can be the case. I think it was the recent case in Dublin. The woman presented with the suicide case. The doctors made a decision to take her beyond viability to safeguard the life of the unborn child, but also to help treat her psychological condition. But looking at the psychological well-being of women, Patricia Casey has very clearly outlined that those women must be cared for in the same way as we would care for another unpregnant person who may be suicidal. Anything else, Liam?
Yes, I mean, obviously, abortion is abortion, no matter whether it happens in the private sector or the public sector. One of the main dangers that we see, and one of the principal reasons that we support this amendment, is the possibility that of something developing along the same lines as the experience in Canada. Canada had a law very, very similar to ours up until 1969. It was replaced then by a more liberal law, supposedly on health grounds. That very quickly ran into the courts and arguments over, well, what exactly does health mean? You know, at what stage of health is an abortion lawful? Within 10 years, the new law was basically totally undermined. The actions of an abortionist, Henry Morgentaler, who opened up clinics and basically presented himself, for prosecution. And we're worried that that very same situation could happen here, where there's the best way to change the law would be to break the law, and we see that this would be a reinforcement of the current situation, and basically just simply putting things back to the way they were before Mary Stopes arrived, and hopefully preventing an escalation. We think if they're left to sit there, then they will eventually keep moving gradually, incremental steps towards what their ultimate aim is full-blown abortion along the same lines as the rest of the United Kingdom.
Although they said that that's not the case.
Well,
to be fair.
They would say that, wouldn't they?
But why not just accept that they're going to act within the law and take their word for it?
Well,
What's wrong with that
if
approach?
It was, if it was the Boy Scouts of America or somewhere, then maybe you would believe them. But the fact that they have such a terrible record of breaking the law, transgressing it, not only in countries like Kenya and Zambia and South Sudan, but even in the United Kingdom, they have performed sex-selective abortions, and that's something that's. It just undermines the credibility of an organisation. If, on the one hand, if your conscience is clear about performing an abortion, then telling an expedient lie is not beyond them.
Chair, could I just refer back to that? In 2012, there was an international symposium on maternal health organised in Dublin. I attended, as did Liam, and there was a very clear agreement from doctors throughout the world, International Forum of Doctors who had been involved in maternal care. Some of those doctors were cancer specialists. Some of them were involved all were involved in the care of women. And they all came together, and the statement was very clear. There are no circumstances when the life of a mother may only be saved through the deliberate and intentional destruction of her unborn child in the womb. And I think that evidence is continuing to be presented throughout the world. The American obstetricians and gynecologists have also made a statement similar to say that there's no medical necessity to destroy the life of a child in order to save the mother's life.
Sorry.
No, go ahead, sorry, okay, Chair. And the reason why I go on to it, because, I mean, in terms of the amendment before us, in terms of our consideration, it says it shall be a defence that acts ending the life of an unborn child where lawfully performed or premises operated by a health and social care trust. You would be opposed to that as well as a defence?
No, the fact that, I mean,
It
that's
may be.
basically just saying what the law
Yeah.
is now.
Yeah.
And that's...
But that's what I'm asking, but are you opposed to that? Do you think that's a good law or a bad law?
Are you talking about whether the existing defences in Northern Ireland law, would I approve of them?
Yeah.
No, because I mean, Alec Bourne, who's basically the founder of the law that we have now, the case law. I mean, it's his action. He regretted it. I regret it. It's a tragedy that the law in Northern Ireland doesn't protect all children. But having said that, the mechanism there is based on actual threat. I mean, there was no threat really to mental health. Abortion, it's well established now that abortion does not save a woman's mental health. It doesn't save her from becoming a mental or physical wreck. It actually is more likely to drive a woman to suicide. And I have statistics here if you want to have a look at them, just on recent studies on the effects, the mental damage that abortion does to women. Considering the time, I think I'll just maybe give you the paper rather than start listing them out. But how many other? There's 18 different studies. Yeah. No, we think that the law should be applied, and if it is applied, then there's practically going to be no grounds, real grounds, because of the advances in medicine since 1967. And there was an excuse for the House of Commons in 1967 because they didn't know what the effects of abortion were on women. They didn't know half of what we know about embryology and fetology. They didn't have any 2D scans, let alone 3D scans. So, we're in a much better position, and we should learn from the mistakes that have been made. The clause in that actually doesn't specify any particular defence. That clause could allow abortion in a much more liberal regime than there is at present if the law changes, or it could be more restrictive if the law changes in that way. So it's a very neutral clause. It's not really something that's going to change very much on its own. But if you're asking me if I approve of abortion in some circumstances, no.
No, and in general terms, what I'm trying to say is that the clause, whereas the clause deals with whether or not they should be carried out in a public facility versus a private facility, I just want to be clear, and your position is clear. I just want it for the record that it wouldn't matter whether it was private or public. You'd still be
The private-public thing is not part of our objection to
But can I answer?
Yeah.
Because it's very clear that the sole purpose of the law is to protect the unborn child and the mother. And a woman is safer within the NHS if her life is in danger. For example, an ectopic pregnancy, I know that's not coming into the whole abortion issue, but for example, if a woman had an ectopic pregnancy and went to a private facility like Marie Stopes, her life would be endangered through Marie Stopes. They wouldn't have the facility, they wouldn't have the emergency backup as we have in our own NHS hospitals. So in terms of what the law says here, the law says a doctor may have a defence, but that doctor must exhaust every available avenue available through this existing law to ensure that he has protected the mother and the child. Marie Stopes' sole purpose is not to protect an unborn child, is to provide an abortion which will take the life of an unborn child for a fee. And as Liam has said, we are a pro-life organisation and we want to protect both mother and child. But the reason why we're presenting the evidence here today is because Marie Stopes has never got the intention. Their sole purpose is to abort unborn children, whereas the NHS here in Northern Ireland will work within the law here that clearly protects mother and child, and we would present the evidence here that the NHS is the best place to protect mothers and their unborn children.
Okay, thank you, Chair.
Mr Pooch?
Thank you, Mr. Chairman. Mr Gibson, you made a claim there that, I think it was Mary Stopes who said, we're carrying out abortions on the basis of sex in some instances.
Yes, there was.
Yeah.
Let me see if I can find the name of the woman. Tragically, this came to light because the woman died. I think it was Sabjit Lal, 29, from Bradford. She died after an abortion was arranged by Mary Stopes in Leeds in 1993. Mrs. Lal wanted an abortion when she found out that she was expecting a baby girl. Now, strangely enough, the poor woman, and yet the coroner blamed her, called her a deceptive and manipulative woman, and said nothing about the abortionists, which seems to be very, just so unjust. But I mean, obviously, there's moves afoot to try and curtail abortions on the grounds of sex within Britain now. We'll have to wait and see what happens there.
Yeah,
but at the moment, it is unlawful.
Yeah.
It's just that that's not being respected.
Yes, and it was debated recently at Westminster where evidence was given. I think there was an amendment to a bill, an amendment to the 67 Abortion Act calling for the clarification on sex selection due to BPAS and Mary Stopes providing abortion for baby girls, and I think that was exposed by the media.
Well, it sort of very clearly fits with what Amnesty International were telling us last week. Because what they were saying was that the reproductive rights of the woman always trumped the right of life of the child. And when it came to the term of the pregnancy, there was no length of time that was an issue for them. When it came to a reason, there was no reason that was strong enough to go against termination if that was the desire of the woman. So, that I suppose is what some people believe. And I know that I've had the debates, Mr. Chairman, with people who have described the unborn child as just a cluster of cells. Indeed, last week we had Mr. Dixon here who was posing us questions about the rights of the woman, referred to the right of the woman to have cancer removed from her body. I thought was an absolutely appalling comparison to make to the removing of an unborn child. And I think that if we have Mary Stopes engaging in that type of activity, that is just something which is quite shocking.
Mr Dixon?
Chairman, I'm not pleased, but I'm content that Mr Pooch has raised the issue of my comment last week, and I need to absolutely nail the lie of the permutation that has been put on that comment. The comment was made in the context of comparing paid for medical services and the National Health Service, and setting out the circumstance where someone has been given a diagnosis of cancer and is told that perfectly safely you can have your operation a number of weeks in the NHS, but they may opt to have that operation instantly or as instantly as possible, certainly in a shorter period of time. And likewise, when a woman under the very restrictive, and I'm absolutely clear about this, under the absolutely restrictive legal right that she could have to have an abortion in Northern Ireland, the question was, should she not be in a position to make exactly the same decision? Because for many people, there will be very strong emotional requirements to deal with the situation as soon as possible. That was the context in which the comment was made, and I bitterly resent it being twisted in the way it has. Chair, can I ask just one question of the parties here, and welcome the comments that they've made. Can I ask each of you, maybe you have a collective view, but just as organisations, can I ask you, do you have a view on the morning after pill?
Certainly the Society for Protection of Unborn Children, and I think I said this actually in the submission that I put forward. We're opposed to the intentional killing of unborn children through abortion, whether by chemical or surgical means, including the use of drugs and devices to cause the abortion of an early embryo.
That's fine. I just want you just to be absolutely clear. You are opposed to the use of the morning after pill.
It's an abortifacient.
Yes.
It's
And you shared.
now, having said that, it has several effects.
Yes.
It can actually prevent ovulation.
Yes.
But its action as an abortifacient.
Yes. Yes.
Yes, we're opposed to the use of abortifacients.
Okay. And that was a view I think the Evangelical Alliance were not necessarily promoting the view, but they were questioning that last week with us as well. Do all of you share the same common view?
Well, we are pro-life representatives
Yes.
here, so if a chemical or a surgical method, whatever it may be, is used to destroy the life of an unborn child, yeah, we would be opposed to that.
Yeah.
We recognise, as Liam said, it has a number of mechanisms, but the main intention is to stop the implantation of the already conceived embryo. But we're here today to speak about the well-being of mothers and unborn children, and that's basically what I think is very, very important. Whether Marie Stopes should offer care to women in crisis pregnancy or the medical needs of women, or should the NHS hospital, and we believe that the NHS is the best place.
Yes, okay. Just a confirmation.
Yes, yes.
And therefore, regardless of whether it's Mary Stopes or Boots the chemist, or indeed a GP, you are opposed to the morning after pill.
Well, Marie Stopes' sole purpose is to break the law, to change the law here, and the majority of people, and I would say every woman who uses Marie Stopes is not using it for the morning after pill, is using it in a crisis pregnancy. We wouldn't need Marie Stopes to provide just for the morning after pill, because we have Boots, we have Brook Advisories and others.
My question was not about Mary Stopes. My question was to get a very clear answer from you. It doesn't matter who the supplier is.
Life begins at conception.
Okay.
We want to protect it from conception.
And in those circumstances, as three organisations, you do not believe that the morning after pill should be prescribed.
We believe life should be protected from conception.
We make no apology about that. We're not trying to.
No, and I'm not. I want to be absolute. I want to be absolute.
If you're going to say that life begins at conception, then you have to defend.
And I want you to be absolutely clear about that, because concerns have been raised with regards to whether this amendment could lead to a legal challenge to the morning after pill. The Human Rights Commission, for example, have raised that issue with us today.
Well, personally, I don't
think
that will happen. But the Society of Protection of Unborn Children brought a case I can't remember, some years ago, and it was the court rejected that. So it's unlikely that you know that
might be useful and I'm here, Mr. Poots is saying, but it might be useful if, and indeed the Human Rights Commission made reference, I think, possibly to that case. They weren't quite sure of the exact reference, but I think that was the case. But I think the argument they were making, and I'm not taking sides in the argument, I'm just simply putting the point to you, the argument that they made was that the law in England has been determined with regards to that, but that I think the words they used, the widely drawn context of this particular amendment could include the morning after pill.
I think they're looking for some argument against it. I don't think it would really.
Helpful.
I mean, legal advice would probably tell people not to take a case. You know, if it's already been taken and lost.
And all I have been trying to do, but all I've been trying to do is to test out that theory and see whether there is a genuine view that it is a fear that for some people who support the morning after pill that this would have that effect, or that you're generally satisfied that that is not really a runner.
Certainly, it's not on our cards because it's been tried, and it's too late now to go back and look for an appeal.
No, I understand. Okay, thank you very much.
Any other members? Can I thank you very much for coming this afternoon, or this evening now? Much appreciated.
Thank you.
Thank you. Okay, members, that's the last session in respect of the amendments. Obviously, the RQIA are to give evidence in the new year in respect of this particular amendment, and then that'll conclude this part of the scrutiny stage. What the committee can do, obviously, is some of the issues that are being identified. The Attorney-General will be before us to talk about his rights of audience amendment, and where there are other questions that members want to ask, they can be identified and put to him in advance so that he can address some of those.
Chair, may I ask just to that point, have there been any other organisations write to us with regards to this matter, and have any others sought to come in front of the committee?
No. There's been none since we had the written submissions before the committee. Have wanted. The only one, RQI, said they didn't want to come before the committee. And they're indicating opposition to it, so I was keen to hear from them as to why. So they were the only ones we had difficulty with, but no one has made representation.
Well, that's fine, just to be sure. Because just once the debate got underway last week and this week, it might be that it sparks someone off to want to come and speak to us. That's all.
Not yet.
Okay, thank you.
But you never know.
You do, that's true.
Okay, the next item is at the meeting on the 19th of November, we considered the LCM on the provisions in the Serious Crime Bill that will relate to Northern Ireland, and agreed that it was content to support the LCM being brought forward by the Minister. A draft report on the committee's consideration of the LCM is on pages 52 to 55 of the meeting folder, so unless there's any proposed amendments to that draft report, then I'll formally just have to go through the normal procedure for approving the report by the committee. Are members content, then I'll proceed. Are members content that the title page and powers at paragraph 1 stand part of the report? Agreed?
Yep.
Are members content that the paragraph section at paragraphs 2 and 3 stand part of the report?
Agreed.
Are members content that paragraphs 4 to 6, which outline the purpose of the legislation, stand part of the report?
Agreed.
Are members content that paragraphs 7 and 8, which outline the committee's consideration of the LCM, stand part of the report? Are members content that paragraphs 9 and 10, which outline the LCM, stand part of the report?
Agreed.
Are members content that the appendices stand part of the report?
Agreed.
Are members agreed then the report be published on the committee webpage and then issued to all MLAs? Agreed?
Agreed.
Okay, just to inform members, the legislative consent motions on the Serious Crime Bill and Modern Slavery Bill are scheduled both to take place for debate in the plenary session on Monday. Item 7, at our meeting on the 17th September, committee agreed that it was content with draft guidance from the Attorney-General for the Northern Ireland Courts and Tribunal Service on the exercise of its function in relation to support for victims and witnesses. The committee subsequently agreed on the 22nd of October that it was content with the proposed statutory rule that would bring the guidance into operation. That rule was laid by the AG on the 11th of November. It's subject to negative resolution. The stat rule comes into operation on the 15th of December. There's been no changes since the policy content of the SL1 was submitted to the committee. The examiner has confirmed that he has no issues in respect to any technical aspects. So if members are content, I'll formally put the question that the Committee for Justice considered statutory rule number 2014/274, the Attorney-General's Human Rights Guidance, Northern Ireland Courts and Tribunal Service Support for Victims and Witnesses, Order Northern Ireland 2014, and has no objection to the rule. Agreed. Item 8, the Legal Aid in Coroners Courts Bill has now received royal assent, and the legislation governing civil legal aid has transferred from the 1981 order to the Access to Justice Northern Ireland 2003 order, and civil legal aid has become civil legal services. In order to commence civil legal services under the 03 order, it's necessary to bring forward a range of subordinate legislation. As part of this, the Department is proposing to bring forward 2 stat rules. The draft remuneration order replicates existing legal aid legislation, which sets out the remuneration arrangement for fees payable to legal profession and other expenses associated with civil legal aid, such as expert witnesses. It has been drafted to facilitate introduction of new fee arrangements, as these are developed as part of the Department of Justice's legal aid reforms. The Civil Legal Services Procedures Regulations will cover the procedures for making decisions about the funding by the Department of Civil Legal Services and will largely replicate the current procedures, with 3 main changes that relate to the redefinition of assistance and representation, authorisation, certificates and grants, suspension, discharge and revocation of funding. The Department intends to conduct a short-term consultation on the draft regulations with key stakeholders, so if members are content, we'll consider the proposed stat rules when the results of that consultation are available. At our meeting on the 10th of September, the committee considered a written paper from the Department outlining the Attorney-General for Northern Ireland had invited the Minister to consider making legislative provision to confer rights of audience equivalent to those of barristers in private practice on any barrister or solicitor working in his office and designated by him. Such provision would sit outside existing provision on solicitors and barristers' rights of audience prescribed in legislation and the Bar Code of Conduct, respectively. The committee noted that the Department had issued a preliminary discussion paper to a number of key stakeholders, inviting views on the proposals, and agreed to consider the matter further when responses were available. The Department has now provided a summary of the responses to the preliminary discussion paper and has indicated that many of the responses expressed concern that such provision would fragment the rights of audience landscape, dilute the role of the professional bodies, and be detrimental to the consistency of standards, training and regulation. Others, including the Departmental Solicitor and the Director of Public Prosecutions, requested the same rights of audience for lawyers in their offices if legislative provision was to be made. The Director of Public Prosecution Service and the Law Society both covered the issue when they attended to give oral evidence on the Justice Bill at the meeting on the 19th of November. To advise members, the Minister has indicated he, at this stage, is not persuaded that it is necessary to make legislative provision, which the AG has requested and which others may also seek. While the Minister recognises the potential benefits of suitably skilled lawyers in the Attorney-General's office and those in other offices having the right to appear in the higher courts, he considers that this will be achievable under the mechanism already legislated for in the Justice Northern Ireland Act 2011. He has therefore asked his officials to continue working with the Law Society to establish a timeline for making of the necessary regulations. Once these are in place, the Minister has indicated that the lawyers employed in the AG's office and those elsewhere will be able to obtain rights of audience in the higher courts on the same basis as other lawyers. So members are being asked to note the summary of responses and the decision in terms of the Minister for Justice's position regarding the AG's request for legislative provision around this area. If members are content, we could send this correspondence, the summary of responses, referred to the AG for any further comments he may have.
What was the purpose of the AG's request?
In a nutshell,
He didn't request this just to have some opportunity. I assume that there was some sound cause for it.
And the Director Barra elaborated on it.
I thought so, yes.
In a nutshell, it's because you have got qualified employer lawyers in the view of the AG and Barra and obviously the Departmental Solicitor's Office indicating that they're capable of appearing before the court, but because they're employees under the code, they're not able to, so therefore you need to bring in another lawyer and they do that on behalf of the other lawyer.
And if I recall correctly from Mr McGrory's submission, he suggested it would be much more cost effective to actually able to use his own lawyers as opposed to employing outside lawyers to carry out this work for them.
He did indicate that. I suppose some of the issue, if I have some sympathy for the profession, PPS, Departmental Solicitors have quite considerable number of employees. How do you assure the quality that they obviously feel that they can do? The AG's office has considerably smaller numbers, therefore the standard of quality could be easier to make sure is there. But if you accede the general principle, I think you have to accede it to the AG, the PPS, the Departmental Solicitors.
Well, at this point of time, whenever we're cutting community police officers and everything else because of the strains in the Department of Justice budget, it just strikes me as not that unreasonable a request to make in order to save money without diluting the quality of work.
Well, I suppose where I would want to test out is the Minister is saying he can do this by regulation.
Yeah.
Now, I would like to broaden that out a bit more.
Is there a pay issue here, Chair? Apologies. Is there a pay issue here? I understand that the point of employing lawyers probably costs more, but knowing civil servants,
although you may have a legal qualification, you're employed as a civil servant. Once you are a civil servant employed as a lawyer, you'll be earning substantially more in terms of civil service pay. And that may be a little Trojan horse that we should look to as well.
Been very equestrian today.
More Trojan horses.
Mr. McCartney.
Beware of Greeks. Very good. So, is that what they say?
You're going to start speaking in Greek.
We say it to that all the time, don't we? I mean, in fairness, I mean, and Edmund's covered it. They say, I think we can separate them down and then look at them on a case by case. Because I think the Attorney General, in particular, it's new. So therefore, you know, like, whatever the issues were, you're saying about the quality and quantity under DSO and under the PPS is different, but under the Attorney General, it's an office here. It's an office only recently set up, so I think you need to look, because there may be different cases to be made for each. I wouldn't be opposed or be open to suggestion on the hours, but certainly the AG's case looks very, very strong. Do we hear now? Barra McCrory just last week just opened up the argument rather than make it a strong argument.
At this point, I'm open-minded on it, sir. I just think we should perhaps explore it a little further.
If you're content, we can share the correspondence to the Attorney General. It was his amendment initially. I'd be keen to hear from him how he responds to this. Obviously, on the face of it, there appears to be a little bit of a turf war, and that's fine. We can navigate through that. But if we refer to the AG, we can also pick it up with officials as well, with the department whenever they're up before the committee around this particular issue.
Chairman, it might be helpful as well. Whenever Mr. McCrory was here last week, he did limit the rights that he wanted for his staff to, I think it was higher court advocates. He has a group of staff. It might be useful, if you're interested, you could write to the Departmental Solicitor's Office and ask them just the extent to which they would be looking for the same rights, whether it would be for all their staff or whether they have a particular group of staff as well.
Yeah, we can do that. That was the first I had realised the Departmental Solicitor's Office were on the same.
I'm not sure that they're actually necessarily supporting the proposed amendment, but I think the point they're making is that if it was to go ahead, then they do want the same rights.
Okay, well, yeah, we could ask them if there's a key select group that they think are within their ranks that can do that work. Okay. Item 10, at our meeting on the 8th and 22nd of October, the committee considered written briefings from the department outlining pension scheme design changes needed to the Public Sector Pensions Act 2014, which would be made by way of subordinate legislation subject to the affirmative resolution procedure. The department indicated that the police pension scheme was one of the schemes affected and the secondary legislation needed to be in operation by the 1st of April next year. The department has consulted as required on the police pensions transitional and consequential provisions regulations Northern Ireland 2015, and no specific comments were made. The consultation process also included the Department of Finance and Personnel, as consent is required from that department to make such regulations, and approval was received on the 10th of November this year. DFP aims to have draft regulations for all public sector schemes, including police pension scheme, laid before the Assembly as soon as possible for debate in January. The draft statutory rule, if affirmed by the Assembly, would come into operation on the 1st of April 2015, in line with the new police pension scheme taking effect. So it's just seeking members' views in terms of the proposed statutory rule, or is further information needed, either in writing or by way of an oral briefing. How does this relate to the information that we got from the police officers?
I think these are separate tidying up provisions.
Okay.
The next item we're dealing with relates to the meeting you had with the police officers.
Right, okay. Okay, so there's no comments to be made then on that stat rule. Item 11 then, at our meeting on the 2nd of July, the committee considered proposals for a targeted consultation on long-term reform of police pensions and proposals for a career average revaluated earnings scheme, and agreed that it was content for the consultation on the proposed regulations to take place. The department has now provided an update on the results of the targeted consultation on the proposals for the scheme design, the issues raised and the department's response. The Department now intends to undertake an equality screening exercise with a view to providing the Committee with an SL1 proposal in January next year. Touched on it there just a minute ago. Both I, the Deputy Chair, and some other members met informally with PSNI officers to discuss their concerns about these proposed pension changes, and the Committee agreed at a meeting on the 26th of November to write to the Department requesting further information on a range of issues, including equality implications. So, members, I think on this one you might want to schedule an oral briefing on that SL1.
Chair, this is the issue as well that we sort of touched on last week, where I suggested it would be helpful if we also met with the Police Federation at the same time.
It is. That's
so
the issue.
Are we agreeing to meet the Federation, or inviting them to, if they wish to speak to us?
Well, we can do that.
Or can we do that through this?
Well, I think we'll get the officials in.
Yeah.
And question the officials on the SL1, and on the back of that, if we want to then engage with the Federation or others, we can do that. Okay. There would be time for us to do that.
That's fine. Thank you.
Okay, item 12. At last week's meeting, the Committee received an oral briefing from officials on the draft 2015-16 budget, key priorities and initial analysis of the impact of the cuts in spending. As agreed, a response on the Department's draft budget proposals has been prepared for consideration and agreement to enable it to be submitted for inclusion in the report on the draft budget 2015-16 being compiled by the Committee for Finance and Personnel. It was, I think, in your tabled.
That was just tabled.
That was just tabled today. So it touches on the issues that members highlighted, and if you're content, we'll send that. It doesn't make any firm recommendations, it just covers the areas we talked about, is it?
Yes, it covers the areas that were covered in the briefing with officials last week, and probably it highlights a number of areas where the Committee doesn't have the detailed information to make proper assessment, and likely to want to return to those issues when the detailed spending proposals and the savings delivery plans are provided.
Okay, members.
Sorry, where is that in our table pack?
It was actually tabled in front of you today.
That's not.
I think the only commitment in it was where the Committee agreed last week to ask the Minister to relook at the Probation Board proposals.
Where's the
Sorry, okay.
The issue that you raised, Paul's in it.
Oh, sorry, it's there. It's underneath me.
Oh dear, yes.
Snap.
Paragraph 9, I think, is the one that you're particularly keen in.
You get it?
Yeah. Okay.
Yeah.
Yeah, okay, thank you. Yeah, sorry, that's your response to the Department, sorry. Okay, thank you. That's fine.
Okay, item 13, the Victim and Witness Strategy published by the Department in June 2013 contained a commitment to undertake a review of the criminal damage and criminal injuries compensation schemes. The commitment arose from recommendations in the Committee Inquiry Report that a review of the legislation underpinning the compensation scheme should be undertaken to assess whether it is appropriate and adequate. The Department intends to undertake a public consultation, has provided a copy of the draft consultation document. While the document proposes the retention of statutory schemes to support victims of criminal damage and criminal injury, it also advances a number of changes to reform the existing provisions. Primary legislation would be required to implement changes to the criminal damage scheme. Changes to the criminal injury scheme would require a new scheme to be laid before the Assembly in draft and be approved by resolution of the Assembly. Subject to views of the Committee, the intention is to publish the document on the 8th of December for a 14-week consultation period. Members are content to note that, unless there's any changes. Item 14, as agreed at our meeting on the 5th of November, draft terms of reference has been provided for the inquiry into issues of public confidence around how the criminal justice system has handled allegations of sexual abuse from within the Republican community involving the Republican movement. A copy of the draft terms of reference is at page 483 of the meeting folder, and it's there for members' consideration of any changes, additions, deletions to it that they want to suggest. Otherwise, we will note it.
We would just put on the writer that, you know, we feel that the terms of reference are narrow, but I mean not standing what they are.
Yeah. Okay, members. With that caveat, and we'll duly note it, members are content to proceed. The terms of reference will be referred to the Assembly's legal advisor for advice as outlined in the clerk's paper. Further work will be undertaken on the scope of and methodology then for the inquiry, and that will obviously come back to future committee meetings. Correspondence, there's 10 items of correspondence at pages 488 to 548 in the meeting folder, one item at page 64 to 68 of the table pack, and I'll draw attention to a number of them. Item 6 in the meeting folder is a response from the Minister of Finance Personnel to the committee's request for an update on the PSNI civilian staff equal pay claim. The Minister for Finance and Personnel has outlined that while it has been clearly established that there is no valid equal pay claim on which to base a settlement for this group of staff, he has circulated a paper to the Executive which recognises the moral argument put forward and which he hopes will provide a satisfactory resolution of the issue. His recommendation and any expenditure will require approval of the Executive. So if members are content, we'll forward this information to those individuals that have contacted the committee in respect of this issue. Item 7 is an invite from the Human Rights Commission to attend the launch of its 2014 annual statement in the Long Gallery on the 10th of December from 12 noon to 2 p.m, at which the Right Honourable Dominic Grieve, QC MP, will deliver a speech on reform of the European Convention and European Court, charting the way ahead. So if members wish to attend, you can advise the clerk accordingly. Item 8 is correspondence from the Chief Inspector of Sagini, providing further information following his presentation to the Committee on the 8th of November of the first interim report commissioned by the Committee on an assessment of the impact of the Department of Justice Legal Aid Reform Package. The Inspector has outlined that, as requested, he's made further inquiries with the Criminal Cases Review Commission regarding the impact of legal aid reductions in England and Wales. The Chair of the Commission has indicated that at this stage they have no empirical evidence linking legal aid cuts to increases in cases going to the Court of Appeal. He also expressed the view that in light of CPS and police budget decreases, if there were to be a significant increase in the number of miscarriages, it may be very difficult to disentangle not just whether the increase as a result of reduction in funding, but also to what extent this can be attributed to particular parts of the system. So it's there for members' information. Item 1 in the table pack, we've got correspondence from the Minister of Justice providing an update in relation to the payment of RUC widows' pensions under the Public Service Pensions Act, Northern Ireland 2014. The Minister indicated that the legal position regarding eligibility under Section 30 has now been clarified. The Minister for Finance and Personnel has confirmed that he does not consider Section 30 to be repercussive to in Northern Ireland or Great Britain, and the financial treatment has been agreed with the PSNI and DFP. The Minister has therefore given approval for payments to RUC widows to commence, and those payments will be backdated to the 1st of July 2014, which is when the provisions in the Act were to take effect. Item 2 is an invitation to meet the Latvian Ambassador, Mr. Andreas Tekamanis, on Wednesday the 10th of December. I'm sure that's not how you pronounce his name. Over lunch in the members' dining room, and this will be the Ambassador's first visit to the Assembly since his appointment in May 2013. It coincides with Latvia's forthcoming EU presidency, which begins in January. So obviously that'll be just before the Justice Committee meeting. So any members who would be available to attend that, if you can advise the clerk accordingly, that would be appreciated. Is there any comments or correspondence I haven't mentioned, Mr. McCartney?
Just in relation to item number 9 from Mr. John White, can we be given a copy of the replies that comes from the departments?
Okay, we'll ask for that.
It's just that there's an interesting, I've always got the same correspondence, there's an interesting point where certain agencies have the power under PIS, and just doing business here at consequences.
Okay, well, we can ask for that. I have no business. Is there any other business? Okay, we'll meet next Wednesday at 2 o'clock. Thank you.
21.